May I be permitted to mention one matter? I have mentioned one matter already, 6/4/2025, and the file already come after a long effort. Kindly accommodate the.
What is the urgency?
Urgency manager is the implementation of the safety commission. Implementation of the safety commission of the retired employees.
দেখে নেবেন তো কি
Already file already a file has come.
My lord, may I
Sorry.
mention, my lord?
দিয়ে দিন দিয়ে দিন হ্যাঁ এই রিটায়ারমেন্টের বেনিফিট গুলো আগে তুলে দেবেন লিখে দিয়েছি কি রিটায়ারমেন্ট বেনিফিট লিখে দিয়েছি লিখে দিন তো রিটায়ারমেন্ট বেনিফিট
My lord, may I give to mention one matter, my lord, that was also previously hard, and it is fixed on 8 April. On that date, municipality was not appear. Again, I have served notice, kindly fixed any date. It was previously hard and it will be appear directions was 8 April. And thereafter, any day, my lord, any day for application, any day, my lord, kindly fixed.
ঠিক আছে আপডেট করে দেবেন এটা হ্যাঁ
I have annexed that order sheet.
My lord, may very short, madam, I'll 2 minutes, I will take, my lord. Kindly let this matter appear to be mentioned, my lord.
to be mentioned.
Yes, madam. Very short matter, I will.
Have you given notice to our other side?
Yes, yes. I have given notice.
Oh, short matter বলছি
Apparently, you will allow me to mention. This state was I have sent the copy again. Previously, I was.
be moved on.
Upon notice, I am mentioning, my lord. Last occasion, I have mentioned, my lord. Lordship directed me to come up with an CAN application, my lord. Now, CAN application has already
Okay,
been
under
filed.
the heading application.
Application.
We have mentioned.
Extremely grateful, my lord.
I have mentioned this matter before Lordship on 28th April, when the matter was appearing in item number 188. And I made the urgency, my pleaded urgency. What is urgency? And accordingly, your Lordship directed the matter to be placed in the top of the hearing list. This is the matter where the petitioner was selected in the year 2006 for the post of clerk of a school. But that was not considered. Then petitioner filed a writ petition. Writ petition, on the other hand, who stood second in the panel, he also filed a writ petition. The writ petition of the petitioner was heard and directed for consideration. That was not considered because the second person who filed the petition, that was pending, that was considered. That matter came up for hearing in the year 2019, and this honorable court directed the DI to consider. While the consideration of the matter, the DI found that since there was no original papers, just discard the prayer of the petitioner for consideration. Challenging that order, petitioner filed a writ petition before the honorable court 2023. But 2024, my lord, this honorable court directed the DI to consider the prayer of the petitioner on the basis of the available documents. Now they have considered on the available document, rejected the prayer of the petition. Then my petitioner had to again come before this honorable court.
But it would be in the month of June. You have waited since long.
I have
Month of June. Only you consider only 8 days are left.
But on the June,
Before vacation, June, in the month of
on the top of, because he's suffering for
Okay, June. Let it appear in the.
I permit to mention, Lordship, for application, the notice has been served, Lordship. Actually, the petitioner is denied the post-retirement benefit, and still, since he has worked there for 2 decades, Lordship, his encashment and gratuity is still pending.
Where is the notice?
Lord, may I permit to one mention, Lordship? Lordship, group 2 hearing matter, Lordship. Kindly inclusion in the list, Lordship.
Retirement benefit গুলো খুঁজে পাবেন
Lordship, group 2 hearing matter, Lordship. Kindly inclusion in the list.
What is the urgency?
Transfer matter, Lordship. Notice was served,
Have
Lordship.
you joined?
No, Lordship.
You have not joined. In the month of June.
Permitted to mention one matter for updation running as item number 95 in your Lordship's today's Lordship. In this matter, one land acquisition case was initiated as against the petitioner, against which the petitioner moved before the arbitration. But the authorities did not proceed with the arbitration. Rather, after considerable amount of time, they sent a letter.
Okay, in the month of June.
No, Lordship, the urgency is that there was a direction of this Honorable Court
Of
to
which
file
year? Which petition of which
of
year?
2024, Lordship. There was a direction upon the respondent to file their affidavit, Lordship. Now, during the pendency, they have not filed their affidavit. Rather, they have called the petitioner for arbitration after 3 years on 15th of May. That is day after tomorrow, Lordship. Lordship,
Arbitration.
yes, Lordship.
So you participate in that.
Lordship, against they did not proceed with the arbitration proceeding for considerable amount of time. They sat tight over it. After that, they sent me a letter to the petitioner telling that your land will be acquired. Challenging that letter, we have come before your lordship in way of writ petition.
And will be section 4 notice in the new act or act 1 when the land was acquired.
Lordship, under Railways Act.
Railway Act.
Yes, Lordship.
Ah.
So after they did not proceed with the arbitration proceeding for 3 years. But during that, they have sent me a letter telling that your land will be acquired. Challenging that letter, we have preferred this writ petition. Now the respondent authorities are appearing in the same, and there was a direction by the Honorable Coordinate Bench to file their affidavit. Now they have not filed their affidavit in opposition. Rather, they have sent me a new notice after 3 years that you come and appear for the arbitration. That will frustrate my prayers, Lordship. Kindly take this matter tomorrow, anytime tomorrow, Lordship. The arbitration is
Tomorrow, not.
At 2 p.m., Lordship. Kindly. There is extreme urgency.
No, tomorrow. You participate in the arbitration.
Lordship,
Ah.
as far as that will frustrate the petitioner's right, Lordship.
Government has eminent dominant power. He can acquire the land. How you can stand in the way?
Lordship,
You are entitled to get compensation.
frustrate my right, Lordship. Kindly keeps the matter tomorrow, Lordship.
Tomorrow in this way.
The matter is
Suddenly,
there is
when the letter has been given to participate in the arbitration proceedings? When? Last week.
I did last week, and the date is fixed on 15th of May. That is day after tomorrow.
Okay, দিয়ে দিন তো দেখি urgency না থাকলে
Kindly fixes a time tomorrow, Lordship.
tomorrow দিয়ে দিন
Yes, Lordship.
2 p.m. এ দিয়ে দিন একটু।
Extremely.
Yes, sir.
Upon notice, I am mentioning for inclusion under the heading hearing. My lord, in spite of direction, the LIC authority has not filed affidavit, and urgency is the petitioner before my lord has been denied the death benefit of her husband. In respect of other two policies, the LIC authority has disbursed the death benefit, but in respect of only one policy, the petitioner.
Okay, in the month of June.
Kindly let it be in the monthly list of June. In the direction was passed. My lord.
July 1st I have no objection.
My lord, may I
The monthly list of July.
My lord, let it be in the monthly list of June.
Actually, this court will get occasion to sit from 23rd, 23.
My lord, may I submit one?
Okay, I have a
Let it be in the
circuit
monthly list of June. If my learned senior friend is unable.
July, same. Before this court, same. Only 1 week in the June.
My lord, may be permitted for mentioning with the Pathard matter. It was lastly appeared on 7th of May. Then the state took the time for 1 day, and it was told by your lordship that for not.
Okay, Pathard matter, you will keep one on the watch on the list, and it would be reshuffled. Okay, 1 day Pathard matter will be upgraded.
Your Lordship, may I be permitted for hearing? This is a very old matter of 2016 and it is ready for hearing, Your Lordship.
In the month of June. In the month of June. A monthly list of June. Yes, call the list.
Number 1.
Sorry, sir.
Pradam for the petition.
Lordship, I am for responding Union of India. Lordship,
This matter, my lord.
as per last order, there was a direction upon us to file affidavit of opposition. Today I am filing affidavit of opposition.
But This matter, my lord, pertains to, my lord, that issuance of certificate of decategorization. My lord, this honorable court has already passed an judgment, my lord, to that effect. And the other honorable coordinating bench also.
So same order with
No,
this.
something different. In the opposition, it is mentioned. That more, acha, call him.
Thing, order may not be, my lord, same. Because, my lord, in the second page of my lord's order, my lord, the situation lordship kindly recollects, my lord, that this incumbents, my lord, was, my lord, put on the under the sick list because of some, my lord, disability that has accrued during the meantime. So after that, my lord, even after expiry of sick list of 6 months,
Not 6 months.
should award. Even after, my lord, the expiry of 6 months, my lord, of the sick list, my lord, the decategorization certificate was not being issued.
Yes.
That was not, my lord, being issued. So for that reason, my lord, I came to the honorable court. And in this meantime, my lord, in that matter, in this meantime, my lord, because of my financial condition, I had to rejoin the duty. But you can recollect. Here, my lord, the difference is that I was put under the sick list on this kind of similar situation, and it went more than 6 months, or rather 1.5 years. And thereafter, my lord, what happened, my lord? Thereafter, because my disability in this particular matter is so severe, I could not till date join. So this is the difference in the matter. So, my lord, only if your lordship kindly sees this order once, my lord's order.
Yes, you have handed over this order.
Yes. So, oh, I'm sorry. I'm sorry. So here, your lordship kindly turns over to the next page, page number 2. The only difference, because this is what I was also requesting, my lord, my learned senior here. Page number 2, paragraph number 2, my lord kindly sees. However, in order to avoid, this part will not be applicable in my case. This particular matter.
Oh.
So this, the next paragraph, further draws my attention to the latest medical will not be applicable. My lord, thereafter, the next paragraph will not also be applicable. So these 3 paragraphs, my lord, will not be applicable in this particular case.
Oh.
Then, my lord, the next paragraph will be applicable to my lord's reasoning in the judgment, my lord, to shed the light on the issue. It would be appropriate. It would be completely applicable. Paragraph number 561A4 of the Indian Railway, completely applicable. The next page. Therefore, as per the provision of paragraph 561B, totally applicable in my case. Admittedly, yes, lordship says, admittedly, the petitioner was retained on the sick list for a period of 6 months. It will be for more than a period of 6 months, during which his medical condition was periodically reviewed. Upon the latest assessment, the medical officer has declared certified that the petitioner is suffering permanent deformity, which is unlikely to show any improvement in the future. This line will not be there because since I did not join, so this occasion did not arise. Thus, from the medical certificate and opinion referred to, it is evident that although the petitioner continues to serve the Railway Protection Force, I am in service, but I am not working. So, this line is not any wrong. He has developed a permanent deformity, that is right, renders him incapable of lifting same firearms, given with the nature of duties expected, discipline completely same. Administrative decision must be absolutely, my lord, in conformity on my case as well. The next paragraph of the judgment of the coordinate bench, and also, my lord, the judgment of the honorable division bench in the next page. Applying the principle established on the internal page number 5, last line, applying the principle established by this bench, a similar case and considering the facts and circumstances of the parent's case, the entire this prayer only I am making this before this honorable. This is what this order, my lord, I am just praying before your lords, subject to correction of my land city. I will not use any reply.
Different to the other case because continuously point number 7. Without informing the meeting of authorities, he has left the particular area and was not reporting to the medical authority for further examination. Lordship, can you please come point number 7 of the objection?
আমি দেখে নিচ্ছি আপনার থেকে দেখে।
Yes.
Point number 7, second, last paragraph. The petitioner did not continue his statement railway hospital and never reported the railway medical authority after submitting the report for statement from Bangalore Institute of Neurology. And as such, it was not possible for railway authority to declare it fit for unfit. Then as next one, Lordship. Second paragraph, as per rule 561 AC, the recommendation should not exceed a period of 3 months in the first instance, after which the case should be reviewed, and under no circumstances should it exceed 6 months. But the medical authority did not get a chance to review the case, as the petitioner did not feel necessary for regular treatment attendance and simply disobeyed the advice of the railway medical authority till date. After the Lordship, point number 10. The middle of the paragraph, the railway administration cannot provide any alternative appointment until and unless the railway doctor declares the petitioner permanently unfit for railway protection post. But the petitioner refrained for further report, treatment from the railway authority, railway hospital. Then, Lordship, point number 12. The petitioner was not under continuous sick list as he was discharged from sick list on 23rd of May 2020. That the period from 24/5/2020, 13/1/2021, the petitioner neither reported for duty nor reported to medical authority. After some time on 14/1/2021, he again reported at medical hospital, railway hospital, Chittaranjan for treatment. Immediately, the medical board was constituted. Petitioner was admitted to hospital. Since the railway hospital, the Chittaranjan locomotive has no specialist in neurology to examine the case, the petitioner was referred to Bangalore on 8th of February 2021. On 6th of March, the petitioner returned to the hospital and submitted report by the Bangalore Institute. The concerned doctor of Bangalore Institute was declared unfit for RPF duty in favor of petitioner. Only advised the petitioner avoid heavy lifting, squatting, and forwarding.
That is the case.
The basis of report of Bangalore medical board was further examination was constituted by the Chittaranjan railway hospital, but the petitioner did not turn up to the railway medical authority, and after 6th of March, he again absented from place of treatment. As per Rule 72.9 RPF Rule 1987, petitioner shall not leave his place of treatment without the written approval of the leave sanctioning authority, except for such exercise as will be prescribed and notified in the order of the railway. But without informing that after discharging of sick list on 23rd of May, the petitioner was supposed to join duty, but he never turned up for duty and remained unauthorizedly absent without any intimation. For unauthorized absence from duty, several callbacks was sent to the petitioner for joining duty, but he did not obey the instruction of the administration. In accordance to the RPF 1957, unauthorized absence is being treated as negligence of duty, and disciplinary action may be taken up against the petitioner. The transfer of ability. Come to CL 30, second paragraph. That on the basis of the report of Bangalore Institute of Neurology, medical board for further evidence for hospital constituted by Chittaranjan railway, but petitioner did not turn up to the railway medical authority since 6th of March. He again absented the place of treatment.
Yes.
On the continuous for a period of 6 months, because not in the important stages, he was supposed to turn up, but he did not turn up. So there was a reaction to file the opposition. I filed the opposition. Let the matter be fixed for hearing for
My learned seniors, my contention is that I was not in the sick list for more 6 months. So, my lord, I have annexed the document in my writ petition only. And my lord, I have been in the sick list from 9th of November 2018 to 1st of April 2020. 9th of November 2018 to 1st of April 2020. So, which is more than 1.5 years.
What continuous?
I have the entire document to show that it is continuous. Secondly, Lordship kindly turns to my lord page number 22. My lord, this is the railway doctor's certificate. My lord, it is a little bit illegible if I may not place because it is a may I place my lord the recommendation here.
May resume duty.
May resume duty avoiding
Avoiding,
heavy object, bending forward or stepping forward, prolonged walking and climbing stairs should also be avoided. So this is the recommendation that has been given to me. I have been working, my lord, in the RPF. I said that if I avoid all this, as has clearly been, my lord, followed in your lordship's judgment, that if I avoid this, my lord, there nothing remains in the RPF. I cannot do my work. And secondly, lordship can appreciate.
but maybe you should have follow the rule,
Yes.
rule, service rules. You should have joined and
But I could not because they have lordship kindly sees my
thereafter
lord's
you have
earlier
not
order.
reported at all.
My lord, lordship kindly sees my lord's earlier order because this contention was earlier made before this honorable court. My lord sees my lord's earlier order. My lord Justice Manta, which is dated 20th of April 2021. This contention was taken. This honorable court was not just satisfied with this.
Judge, what was the latest version?
Yes.
Let the matter be fixed immediately. You want to file a reply? Itself, you were asked
After this, my lord, nothing.
in the order itself, you was asked to join,
Nothing.
but he did not join.
The railway authority may also
Yes.
consider as to whether petitioner is medically fit to serve.
Yes.
He has to join, but
After that, nothing. Now, my lord, senior friend is saying, my lord, that he doesn't have the instruction to that effect. I know.
in the order.
So I have been, my lord, still, my lord, could not work. I am, my lord, I am running without salary till date. If, my lord, it could have been, my lord, possible for me to join and do the same service in the same post, I would have immediately done this.
The paragraph
I just beseech your lordship will kindly see that they cannot insist on me to do something which is not permitted by law.
that is-
Because beyond 6 months, they
So
cannot.
you appear, they will constitute a medical board,
If
will
that,
assess your physical condition.
yes, well, I don't have any problem
If
with that.
they find that you are not in a position to serve more, they will issue.
I don't have any problem to that. But my lord, may I just respectfully submit, I don't have any problem, first I say. And second, they cannot do this, my lord, as per the law.
that was
They cannot do this. They cannot just at their whim, my lord, constitute one after another medical board.
Since expiry 6
Of the
months,
sick This is already established by the Honorable Division Bench that they have been trying to do this thing, my lord, in the earlier matters before the Honorable Division Benches also by saying that no, we have conducted a medical examination after 8 months. Now it seems that he can join the duty. This Honorable Court says that you cannot even do this because if, in fact, my lord, if he could have joined, my lord, he could have easily joined. My lord, this specific instruction of the doctor is that I cannot move forward, I cannot lean backward, I cannot lift heavy firearms.
doctor.
Now, my lord, if I just go and join in the previous post, not only my health will be affected, but also, my lord, for the non-performance of my duty, I will be subjected to disciplinary proceeding and so many other things. Fatalities could have occurred. So, my lord, the respondents have come up with a specific rule for this. They will have to act as per the rule itself.
No, there one thing, the employee is considered by the railway doctor medically unfit for the duties of his original post
Yes. Yes.
by railway doctor.
Yes. Here also, my lord.
He has to join.
The page number, page, abar join. My lord, page number 21, my lord.
After expiry of the period of 6 months,
Yes. Page number 21.
granted under the certificate of recommendation of light duty, employee is considered by the railway or doctor
Absolutely.
medically unfit.
Lordship, page number
So
21.
one chance is to be given
By the medical doctors. That has been done for 1.5 years. My lord, page number 21 kindly sees in the writ petition.
As per last order, he did not join.
Last order is joined for
He was
election.
supposed to join. Railway will consider. Definitely they will consider.
Page number 21, my lord,
He has to appear.
is the Chittaranjan locomotive works, such and such Bardhaman KG hospital. So, my lord, it is a railway doctors. This is my, we are given, my lord, with a copybook kind of thing where, my lord, our periodical medical examinations are placed. So, it is KG hospital of the railway. The next page is of the railway. The next page is also of the railway. Sikh certificate on the next page is also of the railway. So all along, my lord, I have been examined by the railway doctors, nobody else. And I have been, my lord, I was done with that lastly on 1st of April 2020 by the railway doctors itself, who says that I will be kept under the sick list for the 1.5 years. Entirely by the railway doctors. My lord, this periodical, all the medical exam documents, my lord, of the railway hospitals, my lord, from 9th of November to 1st of April 2020 are there on record. May I place, my lord, the entire photocopy of the copybook of my clients, my lord, is handed over to me.
In the first
It
place,
is the medical, lordship can seize this once.
in the first place, he was not continually
Entirely of the medical doctors only.
Order of 28th April, always after he was supposed to join, he did not join. After joining, railway was to consider at what type of job will be given, if at all, what suitable. Then the question of they can but he did not join lordship.
So what do you want without joining, they will issue.
No, my lord, lordship kindly see this is the law. Because for 6 months, if they see that I do not. If they see that I cannot join in the post, they will be issuing the Sikh certificate. It is they, not me. It's not my whim. So after issuance of the Sikh certificate for 6 months, the rule says that it has to be, not may, it has to be, my lord, issued the certificate of decategorization and change of occupation. So in this particular case, my lord, not 6 months. I have been in the sick list for 1.5 years. So, my lord, now they cannot just come and say that now you will be once again medically examined, because that will be beyond the law.
Railways will not take this.
That will be beyond the law, as has been affirmed by the Honorable Division benches.
That is the order of April. Railways will not take.
Alleging inaction on the part of the concerned respondent to issue the categorization certificate in favor on behalf of respondent number 1 to 8, he submits that the railway doctor as well as the doctor of Bangur Institute of Neurology did not confirm the unfitness of the petitioner, did not confirm that the petitioner was unfit to resume duty, stopped. Petitioner, according to him, petitioner was only advised to avoid heavy lifting, squatting, forward bending, etc. Stop. And he submits that a decategorization certificate or a certificate for change of occupation cannot be issued unless the railway doctor, after assessing his physical condition, declared him unfit to rejoin his duties. Stop. He submits that petitioner did not join his duties, did not attend the railway hospital. Stop. Even had he joined his transfer post in Sialda, and even he did not join to his transfer post. Stop. In reply, Mr. Roy submit that petitioner is not in a position to resume his duties. Stop. He submits that taking note of this fact, an appropriate direction should be given. Stop. I heard the learned advocate peruse the material on records placed before me. Record reveals that by an order dated 20th April 2001, a coordinate bench of this court observed that railway authority might also consider as to whether petitioner was medically fit to serve as a constable under railway protection force or might take a suitable decision in this regard. However, no such decision has been taken as yet in deference to that order dated dated 20th April 2021. Stop. To better appreciate the issue, it would be appropriate to refer to the relevant provision applicable to this matter as contained in section F of the Indian Railways Medical Manual. Stop. Paragraph 559 of manual deals with the types of medical recommendation that may be issued under its framework. Stop. It clarifies that medical recommendation can be made by railway medical officer in favor of the employees, including recommendation for light duties or a change of occupation, depending on the medical condition of the concerned employee. Stop. Paragraph 561 within bracket A of 4 of Medical Railway Manual provides that if a competent authority is unable to offer an employee any temporary light duty or an alternative occupation, the employee should continue to remain on the sick list until he is declared fit to resume duty or is formally decategorized. ঠিক আছে? It further stipulates that the period of such waiting shall not exist 6 months. Stop. The clause B of paragraph 561 is quoted as below. Therefore, as per the provision of paragraph 561. If after expiry of period of 6 months granted under a certificate of recommendation of lighter duty, the employee is considered by the railway doctor medically unfit for duties of his original post, but not unfit for the service on other posts, the competent medical officer will issue necessary certificate in the prescribed form as given in annexure Roman 20, double X to the chapter, for a suitable permanent alternate appointment either in the same medical category or in a lower category. Stop. Needless to state that the certificate which is issued in the prescribed form as given in annexure Roman 20 is commonly called as decategorization certificate. Stop. Though the petitioner was retained in the sick list for more than 1.5 years, and during that period, the petitioner all along, under the medical supervision of the railway doctor, the railway authorities should have issued decategorization certificate and the certificate for change of occupation. Stop. At this stage, after expiry of almost several years, the plea as has been raised on behalf of the railway that the petitioner did not report cannot be accepted. Okay. I'm informed that an intercourt appeal was filed. I'm informed that a coordinate bench of this court had the occasion to consider the similar issue in WPA 8620 of 21. Upon examining all relevant aspects, the bench directed the concerned respondent to issue decategorization certificate in favor of the petitioner therein, and in alternative to issue a certificate for change of occupation. Stop. The decision of the coordinate bench was carried in a division bench, in an honorable division bench, by preparing an intercourt appeal. However, during pendency of the appeal, the order under appeal was complied with, rendering the appeal infructuous. Stop. This indicates that railway authority has accepted the decision of a coordinate bench of this court rendered in WPA 8620 of 2021. Stop. So what can be done? You cooperate. Actually, they want to assess your physical condition.
This has been examined by the Honorable Lordship. Kindly see paragraph 13 of the judgment. Lordship has seen, even if it is assumed for the sake of argument, that the petitioner had abstained from meeting the medical officer subsequent to such and such, it is an admitted position that the petitioner was on sick list with effect from such and such. As such, the 6 months period of contemplated in such and rule number such and such was over by such and such. After waiting for a long period of about 8 months, thereafter the petitioner was suddenly declared to be in unauthorized absence, and the medical board was constituted anew, which allegedly examined the petition and declared him to be fit to join his original post. It stares at the face that the fresh medical examination of the petitioner and reversion of the petitioner to his original post to the original duty was patently dehorts the provision of Rule 559 and 56 of IRMM 2000. As per rule such and such.
In the judgment, in the decision of the coordinate bench in WPA 8620 of 2021, The
affirmed by the
bench
honorable division.
categorically observed, the bench observed that after the 6-month period as fixed in the paragraph 561 of the manual, ঠিক আছে, act of declaration, the act of declaring the petitioner to be in unauthorized absence cannot be held to be proper, and that action is in contradiction of the provisions of paragraph 559 and 561 of the manual. Stop. Achha, I do not find any reason to disagree with the decision of the coordinate bench. Stop. Therefore, applying the principle established by the bench in WPA such and such, and considering the fact and circumstances of the present case at hand, stop, the petition is disposed of by directing the concerned respondent to issue a decategorization certificate, or in the alternative to issue a certificate for change of occupation in favor of the petitioner. Stop. Entire process shall be completed within a period of 8 weeks from the date of receipt of a copy of this order.
Particular, he was not reporting responsibility, past report. But of that, he was responsibility.
Oh, Achha, after expiry of the period of 6 months, as specified in paragraph 561, the railway authority is not cannot take the plea that as the petitioner did not report and join, his decategorization certificate was withheld. ঠিক আছে, or আপনি that a petitioner cannot, the railway authority to put it, or railway authority cannot justify their action of withholding the categorization certificate or the alternative certificate for change of option, raising the plea that the petitioner did not join the duties, ঠিক আছে, after expiry of the period specified in paragraph 561 of the manual. ঠিক আছে?
But I'm handing up your lordship of the honorable division bench's judgment affirming this one.
Okay. আমি পেন ড্রাইভে পাঠিয়ে দেব। Disposed of.
But the honorable division bench's judgments order would be, my lord, 18th April 2024 in FMA 651 of 2020.
Where is that?
I'm just handing up to your lordship.
Next.
Grateful.
Item number 2, Group 4 GST matter, my lord. In this matter, I have applied for amnesty scheme under the GST. Amnesty scheme under the GST Act. I have applied. I require to submit withdrawal order, my lord. May I hand over the instruction of the client? And also, my lord, in the meantime, GST authority also issued me a notice and requested to submit withdrawal order. May I submit that?
You want to withdraw the
Yes.
Stop.
as applied under the GST amnesty scheme under section 128 capital M.
Mr. Royal Alert Advocate representing the petitioner. লিখছেন submit that petitioner petitioners do not want to proceed with the writ petition, stop the written instruction as produced Mr. Roy
RAY.
As a Mr. Ray is taken on record. Stop. In view of such submission made on behalf of the petitioner, the writ petition is dismissed as withdrawn.
I'm appearing on behalf of the state, Your Lordship.
Yes, next.
I'm good.
Item number 3.
I am appearing on behalf of the private respondent, my lord. Previous.
I beg to appear for the petition. My lord, encroachment over the government land by the private respondent. My lord, first I refer the page number 11 on earlier writ petition. My lord, the my lord Justice Obhijit Gangopadhyay. My lord, direct the assistant engineer of the Arambagh Highway Subdivision Authority, my lord, an opportunity to hearing petitioner and also private respondent to consider the representation dated 6th August 2019. Page number at the petition, and the entire exercise be completed with 8 weeks, my lord. Page number 11. And subsequently, my lord, in compliance with the said, my lord, order, in page number 13, my lord, the inquiry hearing has been, my lord, conducted, and this is the order, decision of the hearing. My lord, the main conclusive part, my lord, the first point is, my lord, the respondent number 9, Mousumi Mondol and 10, will clear the encroachment from the PWD road department's acquired land within 7 days, counting with effect from, my lord, 20 August 2021, for which notice under section 10(1) of the Highway Act was issued earlier. And next, my lord, the demarcation program will be conducted in assistance with the BL and LRO Goghat 2 as per his convenience to verify the position of cantilever of the house of the respondent number 9 and 10, for which a request letter has already been sent, and further action will be taken after demarcation. My lord, thereafter, my lord, no effect. Well, this is the, my lord, the only for paper order. Thereafter, there is no effect, my lord. I have made a several representation, my lord, subsequently, page number 14 onwards. But encroachment is still.
What is your allegation?
Allegation, my lord, the
private respondent has encroached upon the land belong to PWD.
No, my lord. Totally, my lord. Kindly have a look this petitioner, my lord. Prayer of this previous writ petition. Kindly, my lord, have a maintainability point of this, my lord. Even also, my lord, writ petition, my lord. Kindly this prayer, my lord. My lord, prayer A. He is behind of this, my lord, respondent number 5 and 6, my lord. Just only dispute the regarding.
You are cultivating very on the
my lord. This is the, my lord, prayer of this previous writ petition.
My lord, the previous writ petition has been, my lord, the referring, but previous writ petition already disposed of by directing the, my lord, the then Justice Mr. Obhijit Gangopadhyay directing the assistant engineer, and after, my lord, the inquiry, it is already, my lord, established that they are.
I have understood what you are trying to say. So previous. In the previous petition, what pair was made has no bearing in the present, has no bearing on the outcome of the present petition.
My lord,
it is your stand.
No, my lord, it is not my stand. My lord, the earlier writ petition, what is the order has been directed by the, my lord, justice. That is the main thing, and in compliance with the said order, my lord, the inquiry, the decision has been made.
So according to you, court wants to know, according to it, what is your allegation?
Allegation
that the private respondent has encroached upon the land belong to PWD.
My lord.
How you are suffering?
My lord.
My lord, whether the decision of the hearing, my lord, hearing.
Oh, give answer to the query put by the court.
Because my lord,
How you are suffering.
so my
How
lord,
you will they have encroached the PWD there.
my lord,
How you are suffering.
and my lord, if a person, my lord, encroached a PWD land, my lord, without any permission from the competent authority, and the competent authority, my lord, assistant engineer of Arambagh, already established that yes, and directed them to leave from this, my lord, land, from the encroachment, and that has not been, my lord, this carried out, complied with. My lord, the court will not, my lord, I am asking to myself, my lord, subject to your lordship's correction, the court will not, my lord, take any steps. Because the competent authority itself, my lord, direct to vacate the land because the land is completely occupied illegally.
Okay. So I am passing order, I am directing. The notice under section 10(1) has already been given.
Already complied with lordship galaxy ST or letter.
Now 10
Kindly have a look these photographs. My lord, this is my lord, this is the my lord, go down and my lord, so and my this
From the
this
photograph,
total my lord building of respondent number 5 and 6.
from the photograph, it cannot be, my lord, this established that the where from the
Photographs,
photograph.
orders, government orders, my lord, how?
Aston in the report.
I mean, the patent petition has been papered seeking a direction upon the concern ঠিক আছে ঠিক আছে তো Item number 4.
But I have got the respondent number, my lord, 10 to
Again?
private respondent.
Now what you will cultivate? Huh? Same matter.
No, my lord.
Yes. On that re-inquiry, the line with the condition of counsel.
The allegations, my lord, the private respondents, my lord, obtained the epic card by giving the false information. And on the complaint of the petitioner, my lord, page number 47.
Who are you? Little Indian? Who are you?
My lord, I
And
am
you
my
are
lord,
invoking the regular jurisdiction?
my father
Huh?
name has been used as a legal heirs of the private respondent.
Oh. While is there voters epic card or voters identity card?
And my lord, page
Take
number
me to that page.
47.
47. 47. Number of AC, Egras sir. Name Sitarani Das. Father's name Hemanto Kumar Das. Voter serial number such and
So
such.
my lord, 44 kindly. I am
44.
44, my lord, the inquiry report.
44 are the inquiry report by the joint paper.
My lord.
As per order of the subdivision magistrate. I have served the voter information of Gita Pramani, Priti Suman, Sitarani Das, Amit Das. So such and such, I along with Sri Ranjan Rahul.
My lord, in paragraph 2 of the inquiry report, the findings, my lord, it is clear that the Gita Pramanik was asked to produce her marriage certificate or any other documents in support of her oral claim that late Dhiren Pramanik is or was her husband, but she could not produce any other document except the ration card and Aadhaar card. She further claimed that
Gita showed her original AP Aadhaar card, ration card.
My lord.
My lord, I am appearing question 2 and 3, my lord. It's my lord, 2 and 3, my lord.
So what more you
Inquiry, everything has been done. Again, he wants a re-inquiry, my lord.
Huh?
Full inquiry has been done, my lord. It is concluded that they are resident of 10 years and 1 year and above. AP card has been produced for that. They are regular voter over there.
No, my lord.
Now he wants a fresh inquiry, total full proceeding.
The person who is residing for the very, my lord, last years, my lord, that is not the main issue.
No, you produced that your mother's name has been used.
My father's name, Dhirendra Pramani. So
Dhirendra
what
Pramani,
is
who are you?
on my lord, what the document of, what the documents, on the basis of what documents, his epic card has been made by giving his husband names as my father's name, Dhiren Pramanik. That is the main issue.
If your lordship kindly come
Whether
to page
he is
41.
residing from the 10 years or 50 years, that is the not issue, my lord.
If your lordship kindly come to page 41.
I am
That is the report of
residing
ADM,
in
my
the
lord.
50 years, my lord, from a residence,
Okay, yes.
my lord, that is different thing. But my father name is what my father's
Okay,
name.
yes, yes.
If your lordship kindly come to page 41, what he has annexed, my lord. That is
Yes.
the report of ADM. In reference to the subject cited above, the inquiry report inquired by Sri Sumon Biswas, Joint BDO, Egra 1 Development, along with Sri Ranjan Raul, Election Supervisor, Sri Partho Sarthi Nayak, BL and Vivekananda Assembly. As per the inquiry report, Gita Paramanik has been residing ordinarily as mentioned address for more than 10 years, and Amit Das and others are residing ordinarily as mentioned address for near about 1 year. It is also mentioned in the report that Gita Paramanik and others are registered as elector under 218 Egra AC as per the existing electoral roll, my lord. So they have shown documents, they have got election card, my lord. Now every inquiry has been done.
That is the residence.
Booth
But
level inquiry and everything
whether
has been
his
done.
husband name is, my lord, the
That is,
Dhiren
that is
Pramanik or not,
that is not coming under the dispute
in-
of the election
no,
commission,
no,
my
no,
lord.
no,
They
it
will
is-
see, they will show Aadhaar card, they have shown all these documents. They have, after that, they have got this voter ID
now
card.
what documents,
Now
my
he's
lord?
again challenging the full
On the
procedure, my
basis
lord.
of what documents he has, my lord, include that my father name, my lord, he's included as his husband name. On what documents? I am residing for the 50 years
No,
in
there
the
is
park.
only one Dhiren Pramanik in that locality or in West Bengal. Only one Dhiren Pramanik.
No,
How you can identify you can identify that Dhiren Pramanik, since Dhiren Pramanik he has used his name.
That Dhiren Pramanik, my lord, is the my lord, on the same part, same name. That is my contention. Because, my lord, he is a maid. He is a maid, my lord, came to the house, my lord, and thereafter just to acquire the property, this type of, my
That is
lord,
the main issue, my lord.
manipulated this type of, my lord, voter card. And the main question is completely, my lord, ignored.
One
That
FIR
is
has been
on the what basis they have been written, his husband name is Dhiren Pramanik. When, my lord, this question is asked, now he is, my lord, residing from the 50 years, he is residing in the same part, completely avoiding that part, that whether on the what basis his, my lord, the husband names has been written in the epic card. I am just, my lord, presenting that I am Tanmay Bosu, my lord, my father's name is Jyoti Bosu. Thereafter, my lord, the epic card has been made.
My lord, may I, my lord, submit? I have a private response, my lord.
Yes, yes.
The petitioners claim to be, my lord, the son of, my lord, the Dhiren Pramanik, my lord. Now, my lord, petitioners claim to be the son of Dhiren Pramanik. Good, bad, indifferent, my lord, I am not going into the issue. But the response number 10, my lord, is a legally wedded wife of Dhiren Pramanik. In that regard,
same person.
But same person, my lord, they claim to be the, my lord, the same person, my lord. Now, my lord, what has really happened? The main, my lord, issue is that, my lord, Dhiren Pramanik executed a will and, my lord, bequeathed all his, my lord, properties, my lord, the house that they are now, my lord, trespassed into, my lord, in my name. My lord, we have applied for probate, my lord, that proceeding is pending, my lord, they are challenging that proceeding, my lord. In fact, my lord, they have trespassed into my, my lord, my house, my lord. We have, my lord, taken necessary steps, my lord, for, my lord, evicting them from, my lord, my house, my lord. That is also pending, my lord. My lord, they cannot deny that, my lord. In the meantime, my lord, another proceeding, my lord, has been initiated by me, my lord. My lord, the death certificate, my lord, of Dhiren Pramanik do not record my name as, my lord, the wife of, my lord, the Dhiren Pramanik. My lord, I have made an application before the Register of Birth and Death, my lord. My lord, thereafter, my lord, since no action has been taken, my lord, we have preferred the writ, my lord, petition before this honorable court. My lord, by an order dated, my lord, December 19, 2023, my lord, this honorable court directed, my lord, the Register of Birth and Death and, my lord, the Egra municipality, the Egra municipality, my lord, to take necessary steps, my lord, for determining whether who is the, my lord, whether the death certificate records the name, records the name of the wife, legally wedded wife of Dhiren Pramanik or not. But that inquiry is still pending, my lord. We have taken out and, my lord, the contempt application, my lord, in this regard, my lord, since, my lord, the inquiry was directed to be completed within 12 weeks, my lord. My lord, in this facts and circumstances, my lord, this writ petition has been made, my lord, suppressing few, my lord, facts. My lord, some are, my lord, subsequent events, my lord, some are, my lord, prior events to this writ petition.
No, my lord, there is
But
some
in this regard,
in this, my lord,
this
this
is an opposition.
representation is for my own way that.
Oh, don't interrupt. Don't interrupt. So one civil dispute regarding one will is pending.
Probate proceeding.
Oh. Dhiren Paramanik executed will in favor of Gita Paramanik.
Gita Paramanik.
And declared him as his wife in the will.
Lord, that, my lord, I should not, my lord, say, my lord, I have not seen the
He is
will, my
not.
lord. My lord,
Then dispute cropped up.
then dispute, they
Regarding-
have,
Now they have claiming that who is the original wife of Dhiren Paramanik?
My lord, my
I
mother
claim to be the, my lord.
What is your mother? So your mother
and
particular.
my lord, one thing is,
No,
will signature has been forged.
one thing.
FIR has been registered. That is pending.
You show
That
show
is
that
yes,
that
I
Dhiren
am-
Paramanik had another wife. Have you mentioned this fact in your petition? Have you pleaded that one civil suit is pending?
No, my lord.
Huh?
Yes, my lord.
So take me that.
I have mentioned that the signature of the will has been forged and FIR had been made.
Have you mentioned this fact? This
Yes,
fact
my lord, the
in
will
the
has been
petition?
executed. That has not been probated.
In the petition, don't bypass the question which is being put by the court. You are in habit of doing it. Have you
My
proved
habit,
that?
my lord, if your lordship, my lord, heart is, I am, my lord, tendering my apology. But, my lord, this question is,
Whether have you pleaded that one civil suit is pending regarding the authenticity of the will,
my lord, I am coming.
which allegedly executed by Dhiren Paramanik in favor of Gita Paramanik? You want court will act according to your whims. You will give a nature shape of a dispute, of a civil dispute, according to your own way.
Now, my lord, the civil dispute is make a impact by naming a false name in epic card.
It is sub judice matter unless a court comes to after taking evidence, comes to a definite conclusion that he forged and he misrepresented herself to be the wife of Dhiren Paramanik. How you can say this?
But on the what document basis the
It
epic
is
card has
mere
been made?
oral
My lord?
assertion.
Epic
It
case
is
has been made.
mere oral assertion of a party to a litigation.
Now, my lord, on the basis of oral, my lord, the submission, once, my lord, the husband has been named in the epic card. A probate case has been pending.
Again, I am saying,
My lord.
again, you are a learned lawyer. Unless this thing, it is under investigation by a competent court of law, which take decision after taking evidence from the person conversant with the facts and circumstances and competent to give evidence. It is a question of fact whether this person misrepresented herself to be the wife or used the name of any person as his husband to procure any Aadhaar card or any voter identity card. One criminal case has been pending.
My lord.
My lord. Forgery.
My lord.
So that criminal case is a question of fact will be determined. Then again you have come in the petition.
Now, if your lordships, my lord, ask them to produce any documents regarding the marriage, I will, my lord, submit. He will, my lord, submit. But the epic cut has been made on the what basis?
Okay.
My lord, that point, my lord, kindly be recorded.
Okay, tell me how much cost you will pay.
No, if your lordships, my lord, kindly, my lord, direct on the what basis, my lord.
What I shall direct, I shall tell you. Yeah, we will decide. As the present petition was prepared, seeking a directive upon the concerned
without
Eh?
without any prior notice. My shop room had been demolished without
By whom?
By the district magistrate, my lord, district magistrate has found, my lord, page 56 is the reasoned order, my lord will find. Operating portion, my lord, act, my lord, page 56, last paragraph. My lord, he was a rank trespasser, my lord, an encroacher, did not have any title, my lord, had, my lord, made construction on PWD road, my lord, for construction of this pipeline project, my lord, by which 32 lakhs persons will be benefited, my lord, his construction had to go.
My lord, I agreed with that, but prior to
I will kindly come to the prayers and the writ petition, page 15, my lord. I will kindly see compensation for illegal demolition. My lord, your lordships under this jurisdiction, my lord,
my lord,
usually
no prior notice had been served.
usually do not, my lord,
Suddenly
entertain
they came
such,
and
my lord,
demolished
on the
shop building.
on the prayer of a encroacher.
All materials, building materials, shop materials.
You have committed a wrong.
The photographs at page number
Yes.
page number 21, my lord, the photographs.
By preparing this petition, the petitioner has
Traditional, you also, I am only praying for a day's accommodation because you also, I have fought for 13 instructions.
Not today.
Great.
7.
Well, I am for the petitioner. Well, it's a case of land loser. There is a certificate in respect of land loser for declaring him exempted.
Who is your other side? Railway.
No, no. Hospital land has been acquired. My grandfather's land has been acquired. I made several applications, Right to Information Act. Nothing has been done. For consideration, I'm praying before your lordship. I first.
Land loser certificate or exempted category certificate?
Exempted category. This is the.
You are for the respondent?
I'm for the state. For the state is only.
Yes, what is your instruction?
My lord, instruction, my lord, just kindly give the direction to the concerned, my lord, to submit that for that for the adjudication of this.
Well, unnecessarily, well, let there be a consideration order to the DM. If it is detected, then my lord, I should get or not. Unnecessary.
Who will issue this certificate?
DM, District Magistrate Murshidabad.
So you have not made any application before the DM.
That is correct. That I have seen, my lord. That's
Huh?
I will make, my lord. I will make an application.
Must approach this principal.
I have made application to the LA collector, etc., but not DM.
Calcutta principal or I just forgot. You have to approach the authority.
Correct.
First.
Correct.
Court will not run the administration. They will run their administration.
I will approach.
You approach. If you find that inaction on their part, then you come before the.
Direct only. I will approach. They will consider it within certain period.
Before approaching.
No, I will approach. My lord, kindly give me a direction within 7 days. If petitioner approach.
Acha, present petition has been papered seeking the present petition has been papered seeking a direction upon the
That appeal, my lord, this reply, this has been stated in D7 to ask the BLLRO to supply the information. The BLLRO has not yet been given.
Which appeal?
Page 34. The first application is page 29. BLLRO.
The BLLRO, the appellate authority.
No, BLLRO, we first made. Nothing has been done. We made application.
SPIO means the first, State Public Information Officer and Deputy District Land and Reforms Officer. Okay.
Previous to that, we made application before the BLLRO. Kindly see page 29. Kindly see page 29 once.
If you have not got any desired result under RTI Act, provision is there.
We filed appeal.
You filed appeal under section 19(1). If 19(1) you did not get any relief, then 19(3) second appeal is there. Then come in the writ petition.
Second appeal.
Then come before this.
Before that commission.
Liberty is given. You withdraw the writ petition with liberty to come with better particulars. That would be better for you. Okay. And Mr. Sachan sir submit that the
By Mr. Pinaki Bhattacharya, he couldn't come to court. I only pray not to.
not this week. Not today. Yes, next.
9. The transfer brief, my lord. I am praying for this, not this week.
Not this week.
Item number 9. Item 10. I am appearing on behalf of the petitioner. Petitioner was the.
Have you served?
Yes. It's a long.
No, long back. No, before mentioning this matter before this court for inclusion.
It is listed. It is listed in the daily list. Item number 10.
You are for the respondent?
Respondent.
Okay. Stay of summon issued by the Judicial Magistrate First Court.
Let me tell you the reason behind this. The petitioner was removed from the directorship of the company called La Chemico in 2015. And this is a pharmaceutical manufacturing company which manufactured medicines. And they produced a medicine in 2018. When the petitioner was not in the company, he was removed from the directorship of the company in 2015. And the incident happened in 2018. And they have supplied these medicines in Andhra Pradesh, where the drug inspector has confiscated those medicines and sent to the testing, and then it was found that it was below that standard. So, as a petitioner.
Okay, so ultimately you want the writ court of this honorable court.
Yes.
To set aside a summon issued by the Judicial Magistrate First Court, Tekkali Court, Andhra Pradesh.
Yes, Your Lordship. The reason is that the cause of action, this company is registered here, and the DIR, that is the removal.
Forget about the same. You satisfy the court whether any judicial order is amenable to its jurisdiction. Judicial order passed while discharging judicial function would be amenable to its jurisdiction. What is going on? just I have stated, here just, the court is now flooded with frivolous litigation.
Lordship, in fact, I have judgments to support what has fallen. I have judgments to support what has fallen from your Lordship, that your Lordship's court does not have jurisdiction under Article 226.
Yes. Everything in every court will ask first question. First question which will strike the mind of any person with that first whether Andhra Pradesh or West Bengal, that territorial jurisdiction aspect will be considered later on. You first satisfy that a judicial order is amenable to its jurisdiction.
Your Lordship.
Under Article 226, I am specifying. It is amenable to its jurisdiction. If you say that 227 is a writ, I have no problem in 227. Superintending jurisdiction, supervisory jurisdiction of the High Court. Okay, you can regard this as a writ petition, maybe. But amenable to jurisdiction under Article 226, you kindly bring a judgment or give a judgment.
Your Lordship, first of all, I want to highlight to this honorable court is that we have appeared through our counsel in Tekhali court after the issue of summons, and we have filed the discharge petitions there and section 205 CRPC, which is still sub judice there. So we have
It is answer to the query put to you
your Lordship.
by the 205 is nothing, an application for to dispense with the personal appearance before the court, magistrate court. Yes. 205. Now, what is it? Is the answer?
No, your Lordship. So, my humble submission to this honorable.
And that about territorial jurisdiction. Territorial jurisdiction basically, what I said, shall I say the history?
Lordship, in fact, I'm carrying
226.
Lordship, after the amendment.
Before amendment Article 1A,
Grateful.
ultimately subsection 2, part of cause of action, then part of cause of action, then series of judgment, what will be the part of cause of action? You know better than me.
No, your Lordship. The reason.
So territorial jurisdiction part, another first part is a not. Will you withdraw or you will give trouble to
give some time to submit?
No time.
Lordship,
frequenting the respondents, such as the
Appearing online virtually.
He's
I'm being led by Mr. Ray. He's there online.
Mr. Oliver Rai is appearing.
I'm sorry, man, I could not appear, my lord.
Yes.
But my learned junior was there. I'm sorry, my lord, I could not appear.
Your learned junior has assisted very well.
Very grateful, my lord, very grateful.
Grateful.
Okay. Yes. 11. Yes.
This is my affidavit of service, my lord.
Release the pay
Yes, my lord. Lordship kindly
accumulated
take the trouble
amount
to-
related to referred postal account.
This is my prayer. What happened, my lord?
Mass account, SBI account.
I tell you, my lord.
Yes.
Fact about the petitioner before your lordship, along with the and the husband of the respondent number 5, happen to be brothers. The petition number before your lordship and the husband of
Bholanath Rai and Purnendu Rai happen to be the brother.
yes, Somendranath Rai, Sukumar Rai, and Purnendu Rai, husband of they were brothers.
Brother, yes.
And Rimpa Rai, daughter-in-law. Then what happened, my lord? Purnendu Rai executed a will in favor Ayabula, wherein, my lord, he bequeathed that Rimpa Rai will get certain property and others will be exclusively between the shares between the brothers. Then, my lord, that proceeding was continuing. The Rimpa Rai filed 2 suits declared for partition. All the suits were ended on payment of 15 lakhs lump sum to Rimpa Rai, and he got it. What happened, my lord? Purnendu Rai had some postal savings before the postal authority. My lord, after that, first will probated, 2 suits ended in compromise with the payment of 15 lakhs in ransom, and the will was probated on the basis of evidence of Rimpa Rai that he has no objection. I have got it. Then ultimately I demanded the postal savings which was lying, but most of them have been released. 2 postal accounts which has referred to, which was in the name of husband of Rimpa Rai, that is Purnendu and Rimpa.
that was not released in my favor. Then what my client did, my lord, they filed a contempt against the postal authority in related to the probate proceeding, which ended. The trial court said that this court cannot entertain this type of contempt doesn't lie on the court. Number one, it is not a decree. Second, that postal authority was not a party. You can take the action. Before the probate proceeding, they say, my lord, they cannot release it on the ground that this is a special type of B type account unless Rimpadai gives no objection, or it can only be operated by Rimpadai. Otherwise, they cannot. That's why I have come to this honorable court. Question would be, my lord, after conclusive determination of a right where the parties are there, conclusively held on payment of 15,000 Rimpadai has released, that I'd be showing whether on account of this, since the account operates in the two name, the postal department can withhold release of it. I'll be showing everything, your lordship. First, lordship kindly.
Whether these two accounts are subject matter of the will.
Will, it has been referred.
No, in the will it was referred.
Yes, I am sorry. Will, it has been referred.
Okay, so the schedule of the will. Have you annexed the will?
Yes, yes.
Page 17.
Page 17.
Subject to correction.
Page 17 is the will and giving the operating part. Lord, page 18. আমার উক্ত স্থাবর অস্থাবর সম্পত্তি সকল সম্বন্ধে ব্যাংক, পোস্ট অফিস, অ্যাকাউন্টে, এলআইসি পলিসিতে জমা রাখা টাকা আদি সম্বন্ধে আমার পরলোকন থেকে আমার ভোগাধিকার সূত্রে আমি সূত্রে সরল চিত্রে মনে সজ্ঞানে উইলপত্র সম্পাদন করি এত দ্বারা স্বীকার প্রকাশ করিতেছি যে আমার জীবনান্তে আমার উপরিক্ত সত্তর দখলীয় তক্ত যাবতীয় স্থাবর অপস্থি সম্পত্তি সকল আমার উপরোক্ত সহোদর দুই ভ্রাতা যথাক্রমে সৌমেন্দ্র রায় এবং সুকুমার রায় পিতা সচেন সাহেব মিলার যাবতীয় সম্পত্তি সমল অংশে পূর্বশর্ত দখল প্রাপ্তি হইবে আমার ন্যায়। দেন লর্ডস আই এম স্কিপিং ওভার পেজ 19 লাস্ট পার্ট মিলর বাকি যে সমস্ত অর্থাদি মজুদ থাকবে সেই অঙ্কে ব্যাংক, পোস্ট অফিস অ্যাকাউন্টের টাকা, এলআইসি পলিসির টাকা সমূহ আমার উপরোক্ত ভ্রাতা তুল্যাংশে প্রাপ্ত হইবে। Then lordship kindly turn to two orders of civil court. Here, my lord, page 25, senior superintendent of post office Asansol was a party. Page 26, clause 3, schedule. Savings fixed and MICs in Asansol head post office, account number are not known.
No, where from you are reading?
Lord, I am reading first. I have read page 17.
Page 17, whether the LIC policy has been referred to?
Yes.
In the will?
Postal, my lord. Postal.
Where?
Page 19. ফার্স্ট প্যারাগ্রাফ লাস্ট পার্ট বাকি যে সমস্ত অর্থাদি মজুদ থাকবে সেই ব্যাংক ও পোস্ট অফিস অ্যাকাউন্টের টাকা, এলআইসি পলিসির টাকা সমূহ মায় সুদ সহ আমার ভ্রাতা তুল্যাংশ প্রাপ্ত হইবে। হ্যাভ ইউ লর্ডশিপ গট ইট?
পেজ 19.
Page 19.
Okay, now how the read court can direct the
No, I am
bank
not
to
asking
change
that.
the mode of operation?
what I mean, Lord,
whether the private respondent was appointed as a nominee or nominee.
so that is not there. So bank details, what sort of postal accounts are there, that is not disclosed. According to them, it is a B type. Let's probably call it civil codes conclusive determination. Ended in compromise between the parties, where the postal department was a party, pro forma. But that has been referred to that on getting 15 lakhs, he has relinquished his right. I'd be showing to you two civil courts. After this execution of will, there was two civil court. Both the suits filed by Rimpadai, respondent number 5. That has been ended in compromise with one stipulation that he would be getting 15 lakhs as a whole. That has been between the parties. Ultimately, the probate court also decided on the basis of no objection of Rimpadai. Now the postal accounts are lying with the post office. Post office says, beloved, since it is a vessel B type of account, we cannot release it. Question is, beloved, if a right is determined by the civil court between the parties, right is determined. I'll show you next civil court 15 lakhs. Then, beloved, I have shown the first. Next, Lordship kindly turn to civil courts, order dated page 23. Page 23, first civil court order. This is on compromise between party. Lordship kindly sees name of the respondent number 5, Rimpadai, Somanendra Rai, and
the partisan suit.
Partisan suit. Then Lordship kindly page 25, senior superintendent, post office, Asansol, head office. Last, he was a party.
A partisan suit is schedule in partisan suits. The schedule was total 9 numbers of policy.
Yes.
ICICI Prudential and the policy number 1, 2, 3, 4, 5, 6, 7, 8, 9.
I am not saying anything.
Savings Bank, Asansol head post
Savings
office.
MIC is in Asansol post office. MIS Asansol head post office. Account number are not known yet. Have you Lordship got it? Then at first suit. Then second, another compromise, another suit was there. Clause 3. The terms there.
No, whether bank was party to the suit.
In the post office, I'm not bank, not. I am on bank. Post office.
Oh, the post office was party.
Party.
So that degree is not binding upon that Solenama degree is not binding upon the post office.
I am not concerned. I am concerned, Mullah. A right, a lease covering an account lying in the post office adjudicated between the parties. Then what the post office can do? Had it been a case, supposing, my lord, I have a property, I have sold it, or I have got a probate of a property, then can I not realize from the person where it is lying deposit? Question, where is the post office has released all other accounts. Post office has released on all other account. I have served him. He is not coming forward. I know, my lord, he has no objection because he has remarried. Taking 15 lakhs as a whole out of everything, compromise.
Forget about that. One bank or post office or any institution dealing with the money from the public, he fixed certain terms and conditions, including the mode of operation,
yes,
including how the matured value will be dealt with, how it would be released, how everything. Now suddenly, one dispute cropped up in a family, one partisan suit has been initiated, and that partisan suit has been decreed on compromise. Now the terms and condition of the compromise is binding upon the parties, not upon the post office.
Yes.
Okay. Post office is not bound to change the mode of operation as per the degree of the partisan suit of which he was not party.
You kindly see the clause. Just I'm reading the clause. The defendant 1 and 2, place 29, same thing is in both the suits. 1 to 3 may withdraw all other amounts lying before ICCI Prudential Life Insurance Bank and all other amount, if any, lying before any other financial institution in the name of Purnendu Rai, either in his name or with any other name or persons jointly, whether under nomination or not. The
Oh,
defendants.
I have stated. It is the terms and condition of the compromise. Is binding. Compromise is nothing but an agreement. Okay. And court put its seal on that agreement arrived in between the parties.
Already,
Okay, compromise is nothing.
Post office has released other accounts only in the name of
It is the post office can do.
He has released it. Only they are objecting to this joint. Others they have released. Had it been a case, they are not.
Are you repenting the post office? Yes.
Before, I say, here, my lord, the wife has been made party. They are not appearing, my lord, to assist. The post office want to release the fund, but they are standing in the way, my lord, the mode of instruction, either or survivor. Under the group, these rules, my lord, whenever the one died, the post office is bound under the post office rules to pay the amount to the surviving person. Here, the surviving is the wife. Now it is standing in the way. The post office cannot release. If I release this amount, she can come forward and sue against the post office postal authority. And minor has put question whether there is a list of assets in the ballot. There is no list of assets annexed in the ballot. So there is no post office is not sure whether this includes the probate proceeding. There is no list of assets also annexed, my lord. Your lordship, better, my lord, I direct another service of notice on if your lordship can
you
help.
served upon the private.
Another, let us
Let
try.
what is its stand.
Yes,
one suggestion.
No, that it is running in the list of this court, and
for a
any
long
day
time it
may
is
be
running.
taken up.
I bought.
Yes,
I have.
okay, it was
again I am
served when? In the month of 22.
These 22 matters, my lord.
Having heard the learned advocate appearing for the respective parties and upon perusal of materials on record, I am of the view that presence of the representative of the private respondent
Could be, my lord,
crucial
maybe
for effective adjudication of this petition. Stop. In view thereof, the petitioner is directed to serve a notice upon the where the private respondent resides.
Address given.
Konnapur, Asansol.
Yes.
At least any efforts can be made, my lord, so that the dispute can be settled.
Yes. Respondent.
Present address
Yes,
have
sir. Intimating that the matter shall be taken up for hearing on A hearing matter, it has erroneously come under the heading motion.
Let us do one thing, my lord. He's filing the opposition, my lord. I'm filing the reply.
My lord, kindly, I request my learned friend to supply a copy of the reply.
Affidavit exchanged by the parties are taken on record.
Already supplied, but he has been newly engaged. So I'll supply a copy in that.
Okay.
But there was a direction for me to serve a notice on the state. Notice.
Yes.
It has appeared.
Yes. Mr. Mukherjee is with us. Why?
Mr. Mukherjee is, I believe, my lord, is appearing for the High Court administration, my lord. We always happy.
High Court administration.
The judicial part.
He is for the state.
Different.
Whom we want more?
State is my.
All are present.
We are our friends, my lord.
So whether it will be placed under the heading hearing?
Hearing after vacation.
Kindly gives me an interim order, my lord. What has happened?
What interim order?
Regarding promotion, my lord.
There is no
promotion can be given retrospectively. If you succeed,
my colleagues, my lord, have been promoted.
Maybe retrospectively from the date on which your junior was promoted.
Yes, my lord, right.
It will be given action. List the matter for further consideration under the heading hearing on 26th June. 26th June. Next. 26th June.
26th June. That side of the vacation.
Yes.
Again.
Lordship, on last occasion, Lordship was pleased to fix the matter on returnable motion.
Petitioner made an application at the
Lordship.
state.
Oh.
The
This is the
matter, my lord.
second time as per honorable portion.
Oh.
This petition should be dismissed
Lordship,
because
Lordship, there is a.
Okay, one is affidavit in opposition for the second time. First affidavit opposition in on record.
2020. 5th of February 2020, it was.
Well, it would be supplementary affidavit of opposition.
And as per honorable
Whatever,
portion, that's
whatever it is, my lord, my
and I have
contention before Lordship in twofold way, my lord. That is,
The affidavit of opposition filed in terms of the order dated as in terms of the order of a coordinate bench passed on such and such, উনি বলে দিচ্ছে are taken on record. So many affidavit in opposition.
8 petitioners in one lead petition. That's why I have
the same cause of action, that's why I could not.
not.
There is the matter.
There are
My lord,
eight petition.
yes, 8 lead petitioners.
No, my lord, petitioner is, petitioner number is 8. Petitioner number is total 8.
8 lead petitioner in one lead petition. That is my grievance.
Oh,
My lord, main issue, my lord, involve repudiation of claim due to having fraud committed by their own staff. That is the matter. I have twofold argument, my lord. That
whether it is separate cause of action or
no, my lord. There is the same cause of action. There is the repudiation of claim, my lord.
8 policy holders cannot create one
Repudiation of claim, my lord. That's why I have come before your lordship.
separate policy there.
Kindly, my lord, have a look, my lord.
or you purchase separate policy.
My lord, there is a collective
8% purchase separate 8 policies.
lordship.
How
There
there
is
can be joinder of cause of action?
Lordship, on earlier occasion,
You first satisfied. How can be their joinder of their causes of action?
cause of action is that, my lord, when fraud committed, my lord, all claim has been repudiated by the LIC. Then, my lord,
By one single order.
my lord, fraud committed by their own staff.
By one single order or by separate order?
No, my lord, there is a collective, separate, not separate, on single. Main thing
By
involved-
passing a single order, 8 separate policy was repudiated. Claim under 8 separate policies were repudiated.
Not only
Take me to that order.
Lordship, there is a several policy holder who has been involved in this matter.
Avoiding the question of.
I am appearing before the Lordship on behalf of the 8 policyholder who claim already has been considered.
Okay.
Pension already has been paid. Now they are saying, no, we will not.
You take me to that order whereby the claim under the policy were repudiated.
Milord,
Where is the order?
Milord,
by a single order.
No, Milord, there is no order at all. There is a order passed by Honorable Justice Kaushik Chandra in the last year. Milord, there is a specific direction to show how the policy has been frauded. Policy has been defrauded by the person who is carrying the policy. They have no document at all. That's why I have come before Lordship. This issue already has been closed by the direction of the Honorable Justice Kaushik Chandra in the last year, Milord, July.
They
has a record also.
They have not issued, raised this plea earlier.
Lordship, I am coming to the petition, Milord. Kindly have a look, Milord. One report.
Okay, you can be safe.
Lordship.
If following a same cause of action.
Lordship, that is the.
Or same action of the perpetrator of fraud.
Lordship. Kindly have a look.
Result in repudiation of this claim.
Kindly 28 June, Milord. This court order, the Honorable High Court has passed the order. 28 June.
Yes.
28 June, Milord.
Yes.
When the matter came up before the Honorable High Court was pleased to direct them that and make the statement that LIC not produce any document to suggest that the LIC policy of the petitioner are fake. That are fake. That is the order dated 28 June 2024, Milord. Kindly have a look. That's why, Milord, the petitioner as well as the LIC shall file affidavit disclosing the term and condition of the policy in question of the next date. Milord, they filing the document where they showing payment has been received by them from me as a holder. That is my case. There is a two leg, Milord. I have a two contention. One is fact, another is law point. That is presumption of acceptance. Milord,
yes,
I am coming to the page number 58, 59, and 65. Milord, one report has been submitted.
Number 58.
58.
58.
Petition, Milord. Read petition.
Yes, I am on 58.
Milord, kindly have a look. Para number 2. I am reading, Milord.
Yes.
That report already has been filed by the LIC. No, Milord. There is a part of the charge sheet which has been concluded, investigation concluded by the CBI. They invite the CBI, investigation concluded. In that investigation, they filed the report before the investigation authority and saying that it has already been alleged that Devbrata Roy misappropriated huge amount of money by debiting account code 113811 by way of withdrawing the amount by preparing 234 approx voucher in fake name and debiting the amount code by the using the password and password of the other employee and officer. The name printed on the voucher generated from machine were subsequently already by him in favor of LICI as payee, giving creation a wrong impression of plowback investment which are generally made by the policyholder from the proceeds received by them on maturity, surrender of their policy. The check so generated on the basis of this voucher were deposited in the cash counter of the LIC branch and proposal deposit premium, renewal premium in as many as 114 voucher. The signature of the Devabrata Roy appeared on the body of the voucher, and in many of these voucher of the name of the payee has been already as LICI under his handwriting. Further, 188 of these 234 voucher have been prepared by the Devabrata Roy under his salary roll, that is such and such. In the other cases, in serial number such and such is appeared in any one of the stage of preparation of the voucher to the adjusted of BOC among against the policy with user ID and password. Third column is that it has been alleged in the FIR that 143 check were prepared on the basis of the said 234 voucher generated by the Sri Devabrata Roy. Out of this scrutinize of 47 checks revealed that Devabrata Roy has signed 39 checks and authorized to signature. Further, as per the check mentioned register, that is the record of the LIC. Thereafter, it has been also alleged that amount 1,94 lakhs was adjusted by the Sri Devabrata Roy by misappropriation of fund. By misappropriation of fund, this report filed by the authority, by the zonal manager of the LIC before the investigation of authority, and his name in the name of his family member such and such, and out of those 37 policy, 14 policy amounting such and such were purchased in the name of Devabrata Roy. 12 policy amount to the were purchased in the name of his wife, father, mother, and etc. Milord, kindly have a look, Milord.
He was suspended.
Milord,
Thereafter,
Milord, kindly have a look, page number 55. Milord. It is the charge sheet which has been filed by the investigation authority. They investigate the matter, and that has been interpreted here. Milord, investigation further revealed that Sri Devabrata Roy, Assistant Administrative Officer, Zonal Office, LICI, Kharagpur, then Assistant Branch Manager Cell, LIC branch number 9.
Guessing fake and fabricated vouchers, withdraw huge amount and use the same.
Milord, there is an account in the LIC that is 113811. That account has been used by them, and that kind of fraud cannot be concluded single person. There is a, Milord, despite, it is my contention, Milord, despite having full-fledged audit, inspection, account, and vigilance department existing within the respondent corporation, it is not understood as how such huge scam could continue unchecked for a long time. Milord, there is a chain. There is a chain. Not only Devabrata Roy, there is a chain, Milord.
that is
Number of persons are involved in the department, LIC department.
Okay, you are not concerned with the same.
No, Milord.
You want your money back.
I am coming to the fact.
You want to get back your money.
Milord, kindly, Milord, there is a policy, Milord, that is page number 37 to 46 of my read petition. 37 to 46.
1 minute. কথা কি আছে এইগুলো আছে, এগুলো সব হিয়ারিং ম্যাটার আপনি রিটার্নের মোশন বলে দিন। কন্টিনিউ, এটা 8 নম্বর কথা হচ্ছে 13 2PM আছে। হ্যাঁ, ওইটা আগে নিয়ে তারপরে ওইটা নেবো নাকি? এটা কনফিডেন্সের বিষয়টা। হ্যাঁ, I'm fixing one date, one day.
My lord, there is an interesting point that I want to reveal before your lordship. My lord, kindly.
How
fix
much
the-
you will
fix
take?
Fix the date, my lord. I will take hardly 30 minutes.
My lord,
I
may I
will take.
submit one that coordinate bench are the same cause of action,
Pass the order in favor of me.
pass the order.
Oh.
One by one, I'm coming, my lord. There is very interesting
So
thing.
why you are asking the court to apply? So it would be determined in the same
Lordship,
line.
I have to establish, my lord, once policy has been generated, proposal has been sanctioned, that is the contractual binding.
This liquidation.
I, being a authority, cannot deny.
That.
Number one. Number two, my lord, there is an interesting point. What I am submitting before lordship, my lord, once I binding upon the contract, that cannot be curtailed. I cannot refuse my claim.
Because
That
the
is-
coordinate bench, same cause of action, different petitioner. And different writ petition, not in one writ petition, 8 petitioner.
We were happy if this order is passed.
No, my lord. No, my lord.
Why?
My
That
milord
appeal-
is
Similar
totally
matter.
different. My milord is totally different, milord.
Appeal has
Huh?
not been preferred.
My matter is totally different, milord. In milord, there is a case, milord, where amount has been credited to the LIC. Subsequent amount has been showing in their record. Despite that, they are denying. That is one point. That's why I have some
Certainly
little
not.
point, milord. I request milord kindly fix the matter so that I can satisfy lordship.
To come on 24th June.
No, milord, before vacation, milord, kindly come.
Your-
I will take 15 minutes, milord. 15 minutes, milord. Nothing more than that. Only 15 minutes.
Huh? না না judgment দিতে হবে না judgment চাই
I'll take 15 minutes, milord. Kindly.
Hearing matters, madam.
determination or you take order in the line in line with this judgment.
No, milord.
Huh?
I have
line with this order.
a case.
That the issue
Has
has
to
been
establish
delegated to the
before your
authority
lordship,
to
milord.
consider.
I have a case, milord, that has to establish.
So you
before-
want judicial termination of the issue. So court needs some time.
Lordship, kindly,
Come
I
after
will take,
vacation.
lordship, kindly,
After
milord,
vacation.
humble prayer, milord, kindly fix.
Some I have understood your agony. You are victim of some fraudulent tax.
Lordship, in
Fraudulent tax. You
As per the
milord, how milord that order would be club with me.
to give our
No, milord.
policy papers and such. That's why, my lord, the honorable court was pleased to direct. And my lord, your lordship, kindly see my opposition. We have stated in all. He has different time communicated that you please supply me the quality papers.
Whether they have not annexed the policy paper with the writ petition.
Lordship, I have annexed.
So
That's why I need some time, milord. I have to show before your lordship. I have to satisfy before your lordship.
My lord, your lordship, kindly
no,
see
they
my-
have annexed. Yeah, they have annexed 41.
No, my lord, that is not true. That
He is
my
not
lord-
satisfied.
Your
He
lordship,
is not
kindly
satisfied.
see. I have filed today. Your lordship, kindly see.
She made a mistake.
Each and
She made a
every-
mistake. And
every person, 8 policy holders, each and every person, not only that, all our policy holders are demanded that you have come with your policy particulars and took the money. Your lordship, kindly come to page page 5, my lord, my opposition. Your lordship, kindly
Okay, so in the meantime, during pendency of this year, you approach the authority.
I can show milord original.
With the document relating to your policy.
Milord, I
If
can.
the problem solved, Court is not required to determine anything.
Lordship, kindly pass the order.
Huh?
I can show the
Well,
original policy. book.
Are the learned advocate appearing for the
I can
request?
show the original policy. book.
আচ্ছা আপনি এইগুলো নিয়ে নিন, এপিডেভিট
Can you think about that?
Huh?
On instruction, there is a word on instruction. If that can be deleted, subject to my lord pleasure. Otherwise, they will be difficult. Advocate record will be difficult. There is no instruction from the authorities. There is submission.
Upon instruction.
Yeah, that if it can be deleted. Only that.
In objection, submit. In objection, submit.
If possible, my lord, can you think about that? Otherwise, if the application is made, my lord, they have to affidavit, the department.
Cannot understand.
I also don't understand. Conclusion is mine. My lord.
Why? How they have got so much?
My lord.
So much.
Problem is.
Who is dealing with this file?
Problem is with the advocate on record. If that is there on instruction and in fact and in reality there is no instruction, they will be difficult. Otherwise, I don't trouble you lots.
So henceforth the advocate is to take written instruction from the
that is not done. That is the problem. Otherwise, I will not discharge ballots. Possible, can you think about the matter?
You said I am asking, directing their personal appearance of that officer who has instructed you to mention this matter.
Don't do that. If possible, can you think once?
It is one court of law.
Similar advance with me, with them.
One high court will act as per the dictation of one officer of yes, it is dictation. It is dictation.
Only for him. Instruction.
So if you say that no such instruction has been given,
and that is recorded,
so
they will be difficult.
You filed application. You came here, filed application.
Lawyer cannot affirm.
No, sometimes court is to take firm decision. You is to be firm. Court cannot bow down its head to a officer.
I am the last
No.
person to do this.
No.
Not the officer. Only problem is with the lawyer.
It is a chair. It will remain.
Yes.
It was remain before my birth. It will remain after my death.
Has to be.
Only for
I am holding for certain years. I am to uphold the dignity of the chair.
Has to be.
Yes.
Well, can you think once? If that only word that on instruction it can be deleted, they will be saved. Otherwise, nothing is deleted. I am with you.
They will be removed, eliminated
I cannot say
from the panel.
I cannot say anything. My lord is also aware. My lord is here, this side. So I need not make everything clear to my lord. My lord, can you have a thought about this matter? And if possible, can you delete that part? Nothing else. I have no problem. My lord's order is totally in our favor. As my lord knows, I am, whenever the lawyer is difficult, I try to stand on his side.
File আছে এটা to be mentioned felon তো to be mentioned felon আমি দেখি অনেকটা. So court is to record that it was erroneously recorded. The word erroneously incorporated.
I will not advise.
Okay, you passed out.
No. Don't put my shoulder.
You say that what would be the appropriate sentence which court will write to remove the word upon instruction. You say how?
Only it is wrongly recorded. That will do.
Wrongly recorded. Wrongly recorded by whom?
In the manner my lord thinks is. I will not dictate. I will not advise.
So wrongly recorded by the court?
No. Wrongly recorded by lordship officer. Put the shoulder on them. On their shoulder, the gun should be put. So they will be saved. Otherwise, my lord, I will not trouble you lots. Otherwise, everything is.
I am with Mr. Basu. Only for him we came.
I have refused Mr. Saha. Mr. Saha will think that that I have accepted such plea as you have advanced such but I have refused Mr. Saha.
No. Mr. Saha was here. If it is on the to be mentioned, my lord, he will come.
To be mentioned.
I don't want to put my lord also in trouble. That's why immediately I scold them. This is not possible. Then my lord, looking at their face.
Look, you are not allowing the court to determine the issue.
That your lordship passed the order.
You are saying that during the pendency of the affair, we have reached to an agreement.
The basis of a judgment. That your lordship recorded.
Judgment that if following the proposition laid down in the judgment, this order is passed, we are agreed to accept.
that my lord, agreement at the instance of a lawyer, my lord, appearing for the authority is difficult unless there is in writing. My lord is aware of this. So only for that portion of the order, if your lordship think, kindly think once again. If possible, my lord, kindly save them.
Okay, henceforth, if I get occasion to deal with any matter from podcast authority, I shall ask them whatever you are saying orally, maybe whoever by whom he will be represented,
I also
give it in writing.
I also appear sometime for the port.
So come with writing. Come with writing.
And I am with him. Only for him we are here.
Come with in writing. No oral based on oral submission, no order will be passed.
No, my will not be so rigid when the matter will come. That I
Yes.
do.
Come with written submission. It is our written submission.
I once again request, kindly apply your mind. If possible, kindly delete that. Nothing else.
Okay. Okay, to be mentioned.
Next.
Item number 114.
Hundred 40. Yes, next. Okay.
My lord, in this case, I filed my written arguments with the judgments also.
You concluded your argument.
No. Not in this matter. Other matter I can.
Oh, yes.
In this matter, I just gave the background of this matter and filed my written submission. My lord, para 10 of the order dated 3rd April 2025. The written arguments, compilation of judgment, affidavit in reply filed in the court today on behalf of the petitioner taken on the court. That's my lord, the 3rd April 2025.
Yes.
Let me give the entire background again. My lord, kindly see my written submission.
No. Taken on record. Yes.
Yes.
Copy may be given.
Ready give.
No, copy is not been given. Central. Give me a copy.
In this case, we have challenged certain provision of the law and one notification entry. The cause of that challenge is that entry says the electricity is a service. By delegated legislation, they want to say. Whereas the law says electricity is a goods.
Yes.
One point of contention is that whether the electricity is a service or a goods, we are challenging that notification entry, that entry is contrary to the law and unconstitutional. The second issue arises in this case, there is a corporate guarantee. I have to give it to the bank. When the bank extend a loan to any of my subsidiary company, etc., the bank asks some guarantee to be given, that is called the corporate guarantee, for which no consideration is received. In fact, the RBI said giving the guarantee cannot be the source of income of any company at all. I have put that circular on record with the petition itself. Therefore, the corporate guarantee can never be taxed at all in this case, which they have demanded tax. And they have issued the so-called notice to me under section 74, demanding more than 50 crore rupees. That so-called notice is under section 74, which says so-called notice under section 74 could be issued if there is a fraud, misrepresentation, or suppression of facts. None of these allegations are there in the so-called notice. And only on this ground, this so-called notice has to go. And I have put in my compilation the very recent decisions delivered by the Allahabad High Court, but our own judge from this honorable court, Justice Saraf. If there is no allegation of section 74, that so-called notice can never sustain. At least there has to be some allegations. Like my lord, in the criminal law, if I don't put any allegation of the certain offenses, how that charge sheet can sustain. Another challenge in this, the section 74 and 73 has subsection 5. Subsection 5 is made first time in the taxation law. because the taxation law is there in this country since beginning. They said prior to issuance of so-called notice, a informal intimation will be given demanding the tax, interest and penalties.
Yes.
Our humble submission is that in details I will come to that. That you can't have before a so-called notice to have to test my arguments and to take some benefit of my argument to improve your so-called notice. That is a settled law, my lord. Unless the charges are put against me, I am not supposed to respond to it. But before a charges are framed under section 74(1) or 73(1), they, in my case, they have issued an, which is called the intimation, demanding the same amount of tax with interest and penalty, which they have demanded in the so-called notice, asking my response. And on the basis of that, then they issue a so-called notice. This is the broad background of this so-called notice. Now, my lord, kindly see my written arguments, which has it is the 2nd April 2025, my written arguments.
Yes.
Yes, my lord. The first paragraph, I have narrated what is the challenge in this, which I have already given the brief background. Now, my lord, I am touching upon the first issue in para 2nd. Electricity is a goods. Whereas under the impugned entry 104 of notification number 2, also treating it as a goods, saying duty is nil. At the same time, delegated authority has issued the impugned notification stating that electricity is a service and you pay service tax. What I am doing, my lord, I have the huge property, land parcel I take from the West Bengal authorities, develop that land, make huge commercial building, give it on rent. Like in the airport, my lord, so many kiosks are there, and in shopping mall like this. I have the commercial offices where the big companies take. I have to supply them the electricity. But the electricity company give a big, what we call as a transformer, maybe a 3000 kilowatt, etc. And I give them the sub meters. So same amount what they charge, I have to charge and bifurcate to them. They said, even though you have charged as a separate bill, but we deemed it is as a service and you pay service tax, GST on the value of this electricity. Whereas, my lord, the first judgments which I have quoted, my lord, kindly see the two judgments I have quoted. One in this paragraph, State of AP versus National Thermal Power Corporation, 2002, 5 SCC, 2003, 203. Various paragraph I quoted. This issue came up before the Constitution Bench of the Supreme Court, whether the electricity is a goods or not. The Supreme Court, after analyzing the entire constitutional provision, entire scheme, because my lord, the state list, if we analyze, there are two entries, 53 and 54. 53 entry state list says the electricity duty could be levied by the state government. Entry 54 say the sale of any goods, where the power was there, earlier the sales tax was there, then later VAT came, now it has been repealed, the GST has come by combining the VAT and service tax. Therefore, if I will read this decision, which has categorically said the electricity is a goods. Therefore, there is no quarrel about this proposition. After introduction of the GST, my lord, one matter came up before the Punjab and Haryana High Court. There also, some issue was the CST was there, the central sales tax. And in that context, some observation is made, and it is categorically written by the Punjab Haryana High Court in the case of Carpo Power Limited versus State of Haryana in 2018-12 GSTL 248, para 23. That electricity is a goods. Supply of electricity has a nil rate of duty. Milo, kindly see my paragraph number 2.
Yes.
Page number 2. Page
Yes.
number 2.
Yes.
Is in the top only, first line, in the case of Carpo Power Limited versus State of Haryana, 2018-12. The Punjab Haryana High Court held that the under GST, sale and supply of electricity attract zero rate of duty. Zero rate of duty.
That judgment is not appearing.
Yeah, Madam, I'm sorry. Probably my soft copy is little different than the same. Contents are same, but the printing wise, my learned friend has taken. It is on the first page only. At the bottom of the first page, the two line, in the case of Carpo Power Limited versus State of Haryana. Yes. The Punjab Haryana High Court held that under GST, the sale oblique supply of electricity attract zero rate of tax. Because the electricity is goods, notification for the goods is the notification number 2, where the nil rate of duty is there for the electricity. Therefore, the main controversy is that, can I be held liable to pay GST even though I purchase electricity and I have to supply it to my tenant or the lessees under the sub-meter I have installed? There is no quarrel about I'm paying GST on my renting, etc. There is no quarrel about it. Sole ingredient here is the electricity. I have, my lord, given the judgments, my lord, if my lord, we refer the judgment compilation, both the judgments, my lord. I may just point out the few of the paragraphs. Serial number 7, my lord, the serial number 7 of this judgment compilation, which I handed over on that day.
Yes.
My lord, kindly come to the page number 46, the judgment start.
Real number 14.
Page 46, the judgment start, my lord.
Oh, page 46, yes.
Is the Constitution bench judgment, my lord. And kindly come to the paragraph number 7 first. And that is on the page number, my lord, 56. Page 56.
Yes, yes.
The controversy centers mainly around the question as to under which entry the Andhra Pradesh Electricity Duty Act 1939 is covered. Whether the sale of electricity by NTPCL, the respondent number 1, to the electricity board situated outside the state of Andhra Pradesh and to the state of Goa can be construed as interstate sale or intrastate sale. In that context, my lord, kindly come to the para 20, my lord, para 20. That is on the page 63, my lord, at the bottom.
Yes.
Electricity, what it is. Before we deal with the constitutional aspects, let us first state what
para 20.
my lord, at the bottom.
Yes, yes, para 20, yes.
Before we deal with the constitutional aspects, let us first state what the electricity is as understood in law and what are its relevant characteristics. It is settled with the pronouncement of this court in MP electricity boards that the electricity is goods. That is the main crux. The definition of the goods as given in the Article 366(12) of the Constitution was considered by this court, and it was held that the definition in terms is very wide, according to which the goods means all kind of movable property. The term movable property, when considered with reference to goods as defined for the purpose of sales tax, cannot be taken in a narrow sense, and merely because electricity, electrical energy is not tangible or cannot be moved or touched, like, for instance, a piece of wood or a book, it cannot cease to be a movable property when it has all the attribute of such property. It is capable of abstractions, consumption, and use, which, if done dishonestly, is punishable under section so and so. If there can be sale and purchase of electrical energy like any other movable object, this court held that there was no difficulty in holding that the electrical energy was intended to be covered under the definition of goods. Therefore, my lord, there is no controversy about it. Then, my lord, kindly See further, entry was also analyzed. Para 22 and 23, my lord. Page 65. Next page.
Yes.
Yes, middle of the page, my lord. The list 2, entry 53 and 54, how to be read. We now come to the question on interpretation of entry 53. In the list 2 of schedule 7 schedule, it provides for taxes on the consumption or the sale of electricity. The word sale as occurring in entry 52 come up for consideration of this court in so and so case. It was held that the act of sale is merely the means for putting the goods in a way of use or consumption. It is an earlier stage, the ultimate destination of the goods being use or consumption. We feel that the same meaning should be assigned to the word sale in entry 53. This is for the Portio region in the context of electricity, as there can be no sale of electricity excepting by its consumption. For it, it can neither be preserved nor stored. It is in this property of the electricity which persuaded this court in so and so case to hold that in the context of electricity, the word supply should be interpreted to include the sale or consumption of electricity. Entry 53 should therefore be read as taxes on consumption or sale or consumption of electricity. My lord, I take a pause here. Despite the constitutional 101st amendment by which the GST has come, the old entry was overhauled, entry 54 also, but 53 is untouched. 53 remains there in the constitution as it is, as was prior to the 2016 constitutional amendment. Therefore, the Supreme Court Constitutional Bench has held that even in the entry 53, it should be read as the taxes on consumption or sale or consumption of electricity. Therefore, the whole power for the supply of electricity is outside the GST. It is not, because therefore, even within the GST, it is a nil rate of duty. And the second argument is that since the entry 53 is untouched, therefore, it remains outside the entry of GST. Kindly permit me to read next para also. Para 23, with these two things in mind, namely the electricity is goods and the sale of electricity has to be construed and read as a sale for consumption within the meaning of entry 53, the conflict, if any, between entry 53 and 54 cease to exist, and that two can be harmonized and read together, because the electricity is goods. It is covered in entry 54 also. It is not disputed that duty of electricity is tax, and tax on the sale or purchase of the goods including electricity but excluding newspaper shall fall within the entry 54 and shall be subject to the provision of 92A list 1. That is the central sales tax, my lord. Taxes on consumption or sale of consumption of electricity within the meaning of entry 53 must be in consumption within the state or not beyond the territory of the state. Any other sale of electricity shall continue to be subject to the limit provided by entry 54. That's all, my lord, this judgment. Therefore, my first argument is that once the electricity is goods, how under GST law, a delegated authority has issued a notification by saying that supply of electricity is a service and one has to pay, unless exempted, one has to pay tax GST on that. Even though in the same statute, another notification says 104, notification number 2, entry 104, electricity with a nil rate of duty. That has been noted by the Punjab Haryana High Court, my lord. The next judgment, serial number 8, my lord. Serial number 8. Start from page 72. I will just read one paragraph, para 23 on page 78, my. The Supreme Court decision was long back, but this decision is in the context of GST only, my lord. Para 23, my lord.
Yes.
Section 9 of the HGST Act, H means the Haryana, like here the West Bengal GST Act, levies the tax on all intrastate supply of goods or service or both, except on the supply of alcoholic liquor for human consumption. Section 7 of the GST Act define the scope of supply. It is inclusive provision and includes all type of supply of goods or service or both, such as sale, transfer, etc. In this background, it would be appropriate to note that the petitioner purchased natural gas and use it for generation of electricity. Whereas for the sale of natural gas, the liability to pay tax is on the oil companies under the CST Act, Central Sales Tax Act. The sale of electricity is the state of Haryana is liable to tax under Haryana GST Act. There is no dispute that the sale of electricity is taxable under the Haryana GST Act, though the rate of tax has been fixed at 0%. It has been laid down that even if the rate of tax on the goods is 0, still it is taxable item under the Act. Therefore, my lord, the electricity is still treated as goods under even GST, but with a nil rate of tax, 0 rate of tax, but it remains the goods. Now, my lord, kindly see the impugned notification which I have extracted in the writ petition, my lord. Because all the services, a single notification has been issued, and I have extracted the notification. My lord, kindly come to the page number 5 of the writ petition. Page 4, para 5. Page 4, para 5. Extract is given on page 5. This is the Yes, my lord. Kindly come to the page 5. Notification number 11/2017. Central tax rate dated 26/6/2017.
Yes.
Here the entry 13, my lord, I have given in the table electricity, gas, water, and other distribution services at the rate of 9%. They are asking me to pay the tax under this. This notification is issued, my lord. I have extended in exercise of the power conferred under subsection 1 of section 9 and subsection 1 of section 11, subsection 5 of section 15, and the subsection 1 of section 16. The central government, on the recommendation of the council, that is called the GST Council, on being satisfied that it is necessary in public interest to do so, hereby notify the central tax on the intrastate supply of services of the description specified in column 3 on the taxable bill. Therefore, it says that it is a service, description of the service. Therefore, the electricity, as I already read, once the goods, it cannot be described as the service in the nature of service, my lord, because the definition of the goods remains same as I read from the Constitution Bench decision under Article 366(12)(a). The service has been defined. The 12 was there about the goods. Similar notification is issued, my lord, the IGST Act. Similar notification, which is the bottom of the same page, the same notification. IGST Act, my lord, if the interstate supply is there, then IGST is applicable. If within the state is there, that is called the intrastate supply. The CGST and West Bengal tax is applicable. Let's assume there is a 18% tax is there. If it is within the state, 9% of the West Bengal government under the West Bengal GST Act and the 9% under the CGST Act of the central government. If it is the interstate from West Bengal to the another state, then it will be 18% by the central government, which is called the IGST, integrated GST.
Yes.
Therefore, coming back to my lord, the written submission, the para 3. Para 2, sorry.
Yes.
Yes. Now kindly come to the para 3, my lord. Para 3 of my written submission.
Yes, yes.
Yes, my lord. The charging section of GST is the section 9, my lord. May I just read the section 9 of the GST Act? Because the definition of the goods, service, everything is there under the GST law. My lord, kindly just refer 2-3 line of the section 9, which is the charging section. Levy and collection. May I hand over my
Yes.
Levy and collection. Subject to the provision of the subsection 2, there shall be levied a tax called the Central Goods and Service Tax on all interstate supply of goods or services or both. These three words are important. In the taxation prudence, the what is the judicial interpretation is that the charging section, unless anything falls within the charging section, no tax can ever be collected. Even the Constitution bench, which I will refer the judgment, has said if there is any ambiguity in the taxation law, that tax will fail. Therefore, here the tax is very clearly levied either on the supply of goods or services or both. Now, Milo, kindly see the definition in this, the section 2, which define what is goods, what is service, Milo. Uh, 52, my lord. 52, clause 52 on page 7, my lord. Section 2.
Yes.
Goods. Goods means every kind of movable property other than money and security, but includes actionable claim, growing crops, grass, things attached to or forming part of the land which are agreed to be severed before supply or under a contract of supply. Now, may you kindly see the definition of service 102. 102 clause is 12.
Yes.
It says the service means anything other than goods. Therefore, it make very clear. If something is fall within the definition of the goods, it can never be a service. Therefore, my humble submission is that this notification which has been issued, contrary to the law, constitutional provisions, electricity will remain electricity, my lord. Whether I supply or whether the electricity board supply, DISCOM supply, or electricity generation company supply, NTPC supply, it remain, its character cannot be changed merely because I am a landlord or the having the land on the lease and sublease is to the other person, and along with that I have to supply the electricity, which is the separately build a separate components, the like the water, electricity, certain components, AC, in all buildings it happens so. It can never be a service, cannot be categorized as a service merely to garner more tax. It is probably given. If my lord may recall the Article 265 of the Constitution of India, it categorically said no tax can be levied and collected without authority of the law. And authority of the law comes from the parliament. The parliament made the GST law, categorize goods and service separately. It cannot be categorized as a service. In my case, they are also harping upon, my lord, on the page 2, para 2, my lord, I have also stated, they are saying some nature of composite service. Composite, that definition is also there. 230, my lord, 30, clause 30. Composite supply. But there is no charging section for that. Why definition has been given, I don't know. Page 5. Clause number 30, my lord. 30. Section 2, definition.
Yes.
Composite supply means a supply made by a taxable person to a recipient consisting of two or more taxable supply of goods or services or both. And kindly mark these words. Again, the same word has been used as used in section 9. Supply of goods or supply of services or supply of both. This definition or any combination thereof which is naturally bundled and supplied in conjunction with each other in the ordinary course of business, one is which is a principal supply. That definition has been given. My humble submission is that, my lord, the goods is a separate.
No, Supreme Court has already ruled that the electricity is goods.
Yes.
So further judicial determination is not required.
Because they are saying Electricity is a service through notification, but in the notice they are saying it is a composite supply. Therefore, I am just taking one more minute. The composite supply is not a taxable supply at all. Why? Because in the charging section 9, unless until something fall within the charging section, nothing can be taxed. Section 9 does not talk about composite supply, my lord. It talk about supply of goods, supply of service, or both. Therefore, my lord, if my lord may refer to one judgment of the Supreme Court Constitution Bench, kindly see Mathuram Agarwal judgment on this aspect, serial number 11, my lord, of my compilation of judgment. Serial number 11.
Page?
Page, my lord, is the 106. I will straightway come to the para 12 on page 112.
Yes.
Entire jurisprudence of the validity of the taxation law, my lord. If para 12, my lord, comes, my lord, at the last 5-6 line, my lord, para 12.
Yes.
It says the statute should clearly and unambiguously convey the three components of the tax law: the subject of tax, second, the person who is liable to pay tax, third, the rate of tax at which the tax is to be paid. If there is any ambiguity regarding any of these three ingredients in a taxation statute, then there is no tax in law. Then it is for the legislator to do the needful in the matter. Therefore, the first is very important, the subject of tax. What is being taxed? In the GST, tax is on the goods or the service or the both. I don't know, both word has not been defined. Therefore, if the goods is separately defined, as my lord has rightly said, the Supreme Court already ruled the Constitution Bench, and once it is a goods, there was no occasion for the delegated legislation to come out with a notification saying that it is a service and you have to pay service tax on that. Now, my lord, I will just bring the notice, what the notice has been issued to demanding a tax from me on the electricity bill. There are 3 different years. There are 3 SOCOs notice they have issued. My lord, kindly come to the page number 197 of the writ petition.
Yes.
Yes, ma'am. It says in the top, my lord, kindly note, because I will come back on that section 74. Very first line, my lord, the SOCO's notice. After that, under section 74 of the West Bengal GST Act, read with so and so GST rule. My lord. Now, my lord, kindly come to the paragraph number 3 onwards. And whereas it has been found that the said notice has claimed lighting and other services as exempted supply to the tune of rupees so and so as per the return submitted under GSTR. That means the GST return. Para 4 said it is found that the noticee has supplied service of renting of office space along with other interconnected and interrelated service like maintenance service, security service, water supply service, lighting and other services, air conditioning services, use of common area, etc. during the period from this to this. Whereas all these services as per agreement with the customer are clubbed together and are supplied in conjunction with each other. They are themselves are saying. Whereas the supply of service of renting of office space along with other interconnected and interrelated service is a composite supply, which I just referred, within the meaning of section 230 of the West Bengal Act, as these services are naturally bundled and supplied in conjunction with each other in the ordinary course of business. Whereas this kind of artificial segregation of certain services from the composite supply is not allowable under the law, and the claim of exempted supply is not legally tenable. The entire supply is to be treated as supply of service of renting of office space, renting of movable property, and it is principal supply. The rate of tax will be the rate of tax of principal supply. What they are saying, electricity cannot be segregated. Electricity will be treated as a part of renting, whatever tax you are paying on the renting, you also pay. Whereas I am filing my return, electricity is a nil rate of duty under the specific notification which noted by the Punjab Haryana High Court I just referred by. Therefore, this is the first issue, whether the electricity will be taxable or not. That was, my lord, the first point. Now, my lord, I am coming to the corporate guarantee, my lord. My written submission, paragraph number 4. Written submission. This was the first component on which the tax has been demanded, electricity. Now, the second component is the corporate guarantee.
Yes.
But the corporate guarantee is a guarantee given by the company to a bank or the financial institutions who provide loan to any person. In this particular case, this bank and financial institution has provided loan to my subsidiary company. And by providing the loan, they have asked the holding company to give a corporate guarantee. Therefore, the facts are very clear. Guarantee is given to a bank, not to my subsidiary company. Subsidiary company got a loan from that bank. And my lord, for that, I have annexed both my corporate guarantee on which the tax is demanded. Kindly come to the page 78 of the writ petition. Page 78. Page 78.
Yes.
Yes, my lord. It is a deed of guarantee, my lord. Just kindly read only 1 or 2 lines only. It says after serial number 1, in favor of Axis Bank Limited. So I have given a deed of guarantee in favor of a bank. Bank has not paid me any money. I have not paid any money to the bank, nor my subsidiary company has paid me, because under the RBI guideline, if you give a guarantee, either as a director or a company, it cannot become a source of your income. That means you cannot charge any amount once you are giving a guarantee when any person has taken a loan. Therefore, first component is that because they are asking me to pay the tax under GST law, my lord, section 9, again I will read. It says the supply for a consideration, only then it is a taxable. It will become taxable for non-consideration if it is supplied to a related party. So therefore, my lord, kindly permit me to read section 9 once again. Section 9, my lord. Page 17, my lord, at the bottom.
Yes.
It says the supply of goods and services on the supply of this, on the value determined under section 15, and on such rate not exceeding 20% as may be notified by the government on the recommendation of the, sorry, my lord, before that. On interstate supply of goods or service or both, except on the supply of alcoholic liquor for human consumption on the value determined under section 15 of the Act. Therefore, section 15, my lord, if reads it, and consideration section 2 defined, then my lord, kindly come to the section 7 first. Section 7. Section 7.
Yes.
Yes, the scope of supply. For the purpose of this act, the expression supply includes all form of supply of goods or service or both, such as sale, transfer, barter, exchange, license, rental, lease, or disposal made or agreed to be made for a consideration. That is the word I am asking. Section 7A, third line, it says, if there is a supply for a consideration, in the course of furtherance of business, then only it is taxable.
Yeah.
Now, my lord, there are certain activities which is without a consideration is also taxable. That, my lord, if may read the this section 7 only. Well, kindly come to the next page, clause C of section 7.
Yes.
Activity specified in schedule 1, made or agreed to be made without a consideration is also taxable. May I refer to the schedule 1, my lord? It says the related party. The schedule 1 is on the page, my lord, 161.
Yes.
Yes, my lord. Schedule 1, para 2, my lord. The supply of goods or service or both between the related person. If they are related person, then even if there is no consideration, it will be taxable, my lord. Para 2, my lord. First line. Supply of goods or service or both between the related person. Therefore, it has to be read with the section 7, clause C, with the schedule 1. And related person has been defined under section 15, my lord. There is so much of puzzling, my lord. I'm so sorry. Because one has to go at so many provisions to read. Section 15, the one explanation they have added on page 27, my lord. Page 27. Page 26, my lord, it start the valuation. Page 26, it start with the value of taxable service. Its explanation given on page 27. For the purpose of this act, the person shall be deemed to be related person. If so and so, so and so. Holding and subsidiary company is the related person. But the question is that to whom you have provided the services. If it is called as a service, my argument is that it is not even a service at all. For providing corporate guarantee. Therefore, if the deed of guarantee, which I just show, my lord, there are both deed of guarantee there. Page 78, I have already placed before, my lord. And the another guarantee is there on the page 104. 104 also of writ petition, other guarantee.
104 of?
Writ petition, my lord. Deed of guarantee.
Yes.
Yes, my lord. The corporate guarantee dated 3rd June 2016. That is also one of the point. It was prior even to the introduction of GST, entered by Infinity, that is the petitioner, in favor of the IFCI Limited as lender, who has given a loan to my subsidiary company. Therefore, this corporate guarantee I have not given to the related party. I have given it to the bank or the financial institution. Therefore, unless there is a consideration, it cannot be taxed at all, even if it is assumed for the sake of argument, it is a taxable supply under GST. Therefore, this entire so-called notice demanding tax on the corporate guarantee. Another point, my lord, what I will show from the notice, how they are asking, I have given, let's say, 100 rupees loan was taken from the bank by my subsidiary company. I have given a guarantee of 100 rupees so long as the loan continue. It was started in 2016. They say every year you have to pay the tax 18%, assuming that the value of this service is 110 rupees. Therefore, 110 rupees they are taking as a value and saying 18%. That means 100 rupees loan was taken from 2016, now 2025. Every year they will collect me almost 19 rupees. By the time, even if there is no default, nothing, they say you continue to pay the tax. How the officer has quantified and come out, this kind of, as I shown the judgment of Mathuram Agarwal, what the constitution bench judgment said, there has to be subject of tax. The secondly, the value, how to be determined. It cannot be from the mind of the officers. It has to be from the law, where the 110%. And the third, rate of tax. If either of these components ambiguity, there is no tax at all. Now, my lord, see further in this corporate guarantee, my lord. Corporate guarantee is nothing but a actionable claim. Like, my lord, if there was earlier a controversy, the lottery ticket is a goods or not. That was settled, and Supreme Court overruled its own judgment after 25 years in Sunrise Enterprises. Say that it is a actionable claim, but for the definition given in that actionable claim, That time it was excluded from the definition of goods. But here, my lord, once again, kindly see the definition of the goods. It says it includes 52 clause, my lord. Kindly refer the book, section 2, clause 52. Now I am referring this definition once again for different purpose, my lord. Earlier, I was referring what is goods. Now it says the goods means every kind of movable property other than money and security, but includes actionable claim. Therefore, actionable claim is a goods. Now, my lord, the schedule 3 says actionable claim is not taxable, neither is a supply of goods, nor is a service, my lord. Kindly refer to the section 7. Section 7 says what is supply, and if my lord refer the sub clause 2 and A, my lord, the book, may I refer the page 16, 17, page 16, 17. I'm sorry, my lord, I believe I'm going the same pace which my lord can capture, because the taxation law little is juggling, because there are so many places one has to refer. It is not the one page. It is there's a supply. Supply, my lord, kindly come to the subsection 2 on page 70. Notwithstanding anything contained in subsection 1, the activity or the transaction specified in schedule 3. Then after B, my lord, it refers the shall be treated neither as a supply of goods nor a supply of service. If my lord read the section 9, section 7 and schedule 3 together, my lord, the conclusion is that every supply of goods or service is taxable, but the legislator at their own wisdom has excluded certain activity from the supply of goods or services. Therefore, it will never be taxable. Therefore, my lord, kindly refer the schedule 3. Schedule 3 is on the page 163, my lord, 163. Para 6.
163 of?
Book, my lord, the schedule 3. Schedule 3. Schedule 3, para 6 of schedule 3, my lord.
Yeah. Yes.
The actionable claim. It's schedule 3. Read at the heading, marginal heading, says the activity or the transaction which shall be treated neither as a supply of goods nor as supply of services. Para 6 says the actionable claim. Later on, it is amended also other than specified actionable claim. Specified actionable claim is, they have later on came with the 52A, my lord. That is the like the lottery, gambling, etc. That means the actionable claim which I am talking about, the corporate guarantee is not the specified thing. Yes, my lord. Yeah, that is the 102A, my lord, page 13. Page 13 of the book, page 13. Section 2, it defined clause 102A, specified actionable claim. That means the specified actionable claim made taxable later on, whereas all other actionable claim is not taxable because it is neither treated as supply of goods nor supply of services. Yes. Specified actionable claims as betting, casino, gambling, horse racing, lottery, online money gaming. I am not falling under that. Therefore, my lord, if you come to the my written submission, which I have summarized my arguments related to the corporate guarantee, my written arguments, page 3, my lord.
Yes.
Page 3, 4.1, my lord. I have referred the Indian Contract Act. What is the corporate guarantee? Like the contract of insurance, it depends upon the happening of certain events. Only then something has happened.
Yes.
Providing corporate guarantee is a contingent contract. The performance of that by the guarantor to be done only if that failed to give the loan back.
Upon fulfillment of certain conditions.
Yes, my lord. I am so grateful. The
Yes,
second,
yes, yes.
I have stated that actionable claim, which I have just read, the 4.3 is important, my lord. As I earlier said, every year, so long as this continue, my corporate guarantee, they are asking me to pay the tax. Now, my lord, for my lord consideration, if my corporate guarantee was of 2016, that is the prior to the GST. That means any event, if anything happened, that was the prior to the GST. It under the GST, it cannot be demanded at all, any tax. And the law also defined under, my lord, the GST law, what is the continuing services, continuing supply of services, my lord. May I refer to the section 2, clause 33. Section 2, clause 33. Continuing, kindly refer the book, my lord, page 6. Clause 33 of section 2, continuing supply of services, my lord. Means a supply of service which is provided or agreed to be provided continuously or on recurrent basis under a contract for a period exceeding 3 months with periodical payment obligation. That is important, my lord. With a periodic payment obligation and includes supply of such service as a government may, subject to such condition, notify. Therefore, continuing supply of service only could be when there is a continuing obligation to pay a certain amount for that service. Like I have given my property on the lease for 10 years. Then there is an obligation on the other party. It is for more than 3 months. And he has to pay me on recurring basis, monthly basis, or the quarterly basis rent to me. But in this corporate guarantee, there is no consideration at all. It is not a service at all.
I've understood.
Yes, man.
The question of payment will come upon fulfillment of certain condition.
Yes, and that is also, my lord.
Yes, sir.
Question also, my lord, for consideration: who provides the service? Whether the bank provides the service or I provide the service. Loan is given by the bank. I only give a guarantee. I make only a promise. Therefore, my humble submission is that the corporate guarantee never fall within the ambit of the GST at all. Now, my lord, I have also annexed RBI circular, my lord, with the writ petition. RBI circular, which debar even to for taking a consideration, my lord. I will just read only 2 lines of that circular, my lord. Kindly refer to the annexure 22 of the writ petition, page 243. It starts from page 243, but the relevant is on 252. RBI circular starts from 243.
Yes.
Kindly come to the 252 page, 252, middle of the page.
Yes.
Fourth of the guarantor, payment of guarantee, commission, etc. Where personal guarantee of the director is warranted, they should bear reasonable proportion to the estimate worth of the person. The system of obtaining guarantee should not be used by the director and other managerial personnel as source of income from the company. Banks should obtain an undertaking from the borrowing company as well as from the guarantor that no consideration, whether by way of a commission, broker, fees, or any other form, would be paid by the former or receiver by the latter, directly or indirectly. Or RBI is also banning it. Neither company nor their director can make a money resources for giving a guarantee. That undertaking the bank has to take from both sides, the company who has taken a loan or those who have given a guarantee. The one more part of my lord is a alternative submission, my lord. Even if assumed for the sake of argument, the corporate guarantee is a taxable supply under GST. Whether it will be taxed at all or not, and how it is to be valued. Therefore, my lord, there is a rule 28 is there where how the value is to be defined, my lord. May I just read the rule 28, page 217, my lord, which has been later amended in 2013, my lord. I will read the 28.1, which is rule 28, 217 page. That is, my lord, the GST rules. Earlier we read the GST Act, under which the rules has been framed. This is for the purpose of valuation, my lord. Valuation rule start from rule 27. For our purpose is 28, my lord, is the relevant. It says the value of supply of goods or service or both between the distinct person as specified in subsection 4 and 5 of section 25, or where the suppliers and recipient are related person. Man. Kindly mark this word. I will go to the rule 20.
Rule 21.
Rule 28. 28.
Page.
217.
Yes.
Yes. Kindly see, my lord. Previous page, it is a determination of the value of supply. The rule is made under rule 28 is applicable when there is a related party. Therefore, my lord, my argument is that if the argument of the revenue is accepted, instead of giving guarantee to the bank, I am giving it to my subsidiary company and we are related party. And if there is no consideration that will taxable, that take care for me, my lord. It says, my lord, the sub rule 1, the value of the supply of goods or service or both between distinct person as specified in subsection 4 and 5 of 25, or where the supplier and recipient are related, which is the allegation, we are related person, other than the supplier is made through an agent, shall be open market value of such supply. If the open market value is not available, be the value of the supply of the goods or the services like and the quality. If the value is not determinable in A and B, be the value as determined by the application of rule 30 or 31 in that order. Further, it says the provided that where the goods are intended for further supply as recipient, the value shall be the option of the supplier be an amount equivalent to the 90% of the price charged for the supply of goods or like, which is not relevant. Our case, they are taking service. Second provision, my lord, is relevant. Provided further that where the recipient is eligible to take full input tax credit, the value declared in the invoice shall be deemed to be the open market value of the goods or service. What does it mean, my lord? It says under GST law, if I provide a service to another person, I have to charge tax. And that whatever tax component I charge, that the credit will be taken by them. Let's say I supply any service for 100 rupees to my friend. I will charge 18%. It will cost him 118. He will supply, let's say, for 200 rupees. He will further charge 18%, 36 rupees. But 18% what I have charged from him, he will take credit of it. Therefore, he will pay the balance 30 out of 36, 18 credit, 18 rupees to the government. Therefore, this rule 28 second proviso is saying, if my subsidiary company is eligible for the input tax credit, the whatever I am showing in the invoice, that will be treated as my value. If I am saying nil, I am saying 1 rupees, that will be the value. This has been done to obviate the multiplying the number of unnecessary transactions, because the government is not going to gain anything. When the related parties are there, they are going to take a credit. You can choose your own value. Therefore, in my case, I have not raised a bill, I have not charged any amount. Therefore, there is no question of levying tax. As per the rule 28, it will take care and there will be nil rate of tax. Just I refer to the what the so-called notice says about it, my lord. Kindly refer the, like for the electricity, I have read some components from the so-called notice. Kindly come to the page 197 of the writ petition, my lord. (197) para 7 and 8. 1 to 6 we have already covered. That was about the electricity, my lord. Now about the corporate guarantee. This is the notice issued to us for demanding tax, where it is also found that the noticee has provided corporate guarantee to the banker, my lord. Kindly mark this word. I have provided corporate guarantee to the banker. If I provide it to the banker, the question of assuming that I provided to my subsidiary company does not arise. Of Infinity BNK Infocity Private Limited, a wholly owned subsidiary company, from the term loan availed by them amounting to rupees so and so in the financial year 17-18, and the noticee has provided corporate guarantee to the banker of transactions. Something is written, my lord. The banker of this company name is written. A step down subsidiary company of the term loan availed by the amounting rupees so and so. Whereas providing corporate guarantee services for granting loan fall under the category of credit guarantee service, including the standby commitment guarantee so and so under notification number so and so. They have written. Whereas providing corporate service of corporate guarantee, para 9, my lord, the next page, fall under heading so and so, description of service, notification number so and tax will be levied at the rate of 9% according to that entry. 9% means 18%. 9 of the center, 9 is the state. Therefore, on the basis of that, they have asked the tax from me on the corporate guarantee. Once there is a admitted facts, my lord, I have provided the corporate guarantee to the bank. No consideration I charge. How they can tax it? Now, my lord, 198, a table, my lord, kindly see how they have calculated the tax. Kindly see the page 198, a table is given in the writ.
Yes.
Yes. Para 13, a table is given. Yes, in service of providing corporate guarantee. In table, serial number 2, they say the amount rupees, this corporate guarantee amount was good. It says 110% of this amount. And it was taxed at the rate of 18%, 9 plus 9. This is a charge. So they assume whatever, if I provide 100 rupees guarantee to the bank, my subsidiary company has taken 100 rupees loan. They said 118 rupees I will deemed as a service. And on the 110, every year, 18% is being calculated. This is the one so-called notice I have seen. There are 3 notices, my lord. For 17-18, 18-19, 19-20. Amount is different. Allegations are same to same. All 3 are part of this record. Same. Now, my lord, kindly see just only one line, page 197, first line. Page 197, first line of the so-called notice. Is it issued to me under section 74 of the Act? 74. Now, my lord, kindly see what is the section 74 is saying. When a notice can be issued under section 74. Now, kindly refer the page number 82 of the book. 82 of the book.
Yes.
Marginal heading, determination of tax. Not paid or short paid or inversely refunded or input tax credit wrongly availed or utilized. Thereafter the word, my lord, kindly see, by reason of fraud or any willful misstatement or suppression of facts. These are very old words, my lords. This they have picked up from the Central Excise Act 1944. And these has been interpreted long in the various judgments long time back also. Just sub-rule, subsection 1, may I read it? Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud, willful misstatement or suppression of fact to evade tax, he shall serve a notice to me. The 3 words are used. Therefore, my humble submission is that once they have issued me the notice under section 74, they have to allege first either there was a suppression or either there was a fraud or was there is any willful misstatement. My lord, kindly refer the page 197. They have said nothing. These ingredients, my lord, if somebody says there is a theft, at least ingredient of the theft has to come. If there is a misappropriation, those ingredients has to be fulfilled. In 74, my lord, this First 1 to 6, they are talking about my electricity. Para 7 to 13, they are talking about my corporate guarantee, my lord. And nothing said about 74 section ingredients. If the 74 allegation is not there at all, this so-called notice has to go. And I will cite a one judgment and a most latest judgment from Allahabad High Court, my lord.
Yes.
Yes, my lord, serial number 1 of my compilation, serial number 1.
Yes.
So it is from the Allahabad High Court, my lord, kindly see. It is from our own judge, from this honorable court, Justice Saraf, my lord. The paragraph, my lord, 22 and 25 can be read, my lord. If my lord refer the 24 and 25. 24, in fact, refer the Supreme Court decision. We refer the page para 25, my lord. Para 25, my lord. Page number is page 6 of compilation. Page 6 of the compilation, my lord. Para 25.
Yes.
We find that the impugned so-called notice does not make even a whisper of the fact that the petitioner has wrongly availed or utilized input tax credit due to any fraud or willful misstatement or suppression of fact to evade tax. Therefore, the proceeding initiated against the petitioner under Section 74 of the CGST Act are without jurisdiction for the lack of basic ingredients required under the said clause. So far as the argument advanced by the learned counsel appearing for the respondent that the writ petition against the so-called notice is not maintainable is concerned, we find that it is a consistent view of the Honorable Supreme Court that if the so-called notice is without jurisdiction, the same can be challenged by filing the writ petition before the Honorable Court. And para 26, in the present case, we do not find that the basic ingredients required for initiating proceeding under Section 74 of the CGST Act are present in the so-called notice dated so and so. Therefore, the entire exercise, including the so-called notice, is without jurisdiction, and thus writ petition under Section 226 of the Constitution is maintainable. In view of the aforesaid reason, we are categorical view that the impugned so-called notice is in the present form lack basic ingredients to proceed in the matter under Section 74 of the CGST Act. Therefore, the impugned so-called notice so and so entire exercise is absolutely without jurisdiction and liable to be quashed and quashed. Therefore, my case is that the notice is issued, no allegation, and in fact, the law is more further, my lord. It is not merely the allegation. They have to adduce, the onus is on the revenue to adduce the evidence whether these ingredients exist or not. And I don't want to burden with those judgments because in our case, there is no allegation at all. Otherwise, I have succeeded in large number of cases where in this honorable court has held that the onus is on the revenue to prove these ingredients exist. One judgment of this honorable court, I would like to quote, my lord. Serial number 3. Serial number 3, my lord, page 12, my lord. Para 26, my lord. If I succeed before the honorable division bench in this case, just how the so-called notice to be issued and when. It is para, my lord, page 22 of the compilation. Para 26, there is no record in the impugned order that the appellant refused, failed, or neglected to provide any documents or evidence before the tribunal, where investigation and inquiry were unable to bring to light material which could be the basis for direction to take additional evidence. We find that the such direction in the impugned order have been made without reason. The adjudicating authority cannot direct it to fish out the evidence the Central Excise Intelligence and Investigation Manual require that the so-cause notice to be issued only after proper inquiry/investigation. That is, when the facts used are ascertained and allegation justified. The other particulars in the said manuals relied upon by the appellant also assume significance. The adjudicating authority is to adjudicate the demand in the so-cause notice based upon the allegation made in therein, if there is no finding. Therefore, if there is no allegation, the finding cannot go towards the allegation made in the so-cause notice. That is the crux, my lord, the division bench of this honorable court. Therefore, my submission is that this so-cause notice itself is not sustainable. Now, my lord, the another point which I have challenged section 74 and 75, subsection 5, my lord. Kindly see. Para 5 of my first, my lord, the written arguments. The impugned provisions and the rule are unconstitutional ultra vires. I am harping on the provision itself. The rule, if the provision goes, the rule automatically has to go. Rule is only a procedural things. Section 73 and 74 is saying that prior to issuance of so-cause notice. Now, my lord, maybe refer to section 74 just for a moment. Subsection 5. Page 83, my lord. Page 82 to 83. 82 is start 74. Subsection 5. It says the person chargeable with tax may, before service of notice under subsection 1, for demanding tax, there is a provision subsection 1 which I just read. Prior to that, it says they can issue me a notice, pay the amount of tax along with interest payable under subsection 50 and the penalty equivalent to 15% of such tax on the basis of his own ascertainment of the tax or the tax as ascertained by the proper officer and inform the proper officer in writing of such payment. So what essentially this says, prior to the issuance of the formal so-cause notice which is under challenge, they have the power to issue me another notice to me asking me to pay the tax, interest and penalties. Whereas my argument is that, my lord, there is a settled law. Even if the most dreaded criminal has to be face the entire justice system, he has to be given to face a trial. After an investigation, charge sheet will be filed, a judgment will be delivered. Prior to that, there can be a punishment. Similarly, my lord, there is a settled law under any taxation law. If suppose the departmental officer feel I have not paid the tax, I have paid the short tax, I have evaded tax, then he has to issue me a notice. Notice essentially have to allege why it is so. Notice has to have some evidences. Notice has to have given me an opportunity to file my reply, to appear before the authority, and after that a judgment will be passed. That is the set legal procedure which is there under subsection 1 also, if a notice is issued subsection 1. But in subsection 5, they are directly asking me to pay the tax. No such procedure ki hearing will be given, some order will be passed. Therefore, my lord, see, a similar notice was issued to me under this Annexure P15 on the writ petition, my lord. Page 118 of the writ petition, my lord, kindly see.
So before issuing any before service of notice, they cannot ask you to pay anything.
They are saying you have to pay the tax. My lord, may I read it again? They said before service of notice, pay the amount of tax along with interest and penalty, either on my own determination or the determination made by the officers. The officer has made a determination, issued me a notice to asking me to pay the same amount of tax which they are asking, my lord. That notice is appearing on the page 118 of writ petition, my lord. Before service of notice, they are asking me to pay the tax. In fact, my humble submission is that this subsection is not required. If anybody want to pay tax, anytime he can pay. But the departmental officer want to demand a tax, he has to go through the hurdle of subsection 1 only. He cannot bypass subsection 1. And to my surprise, my lord, I am practicing in the taxation law for many decades. No taxation law has such kind of provisions. This is the summary of earlier central excise law, summary of earlier service tax law, or the VAT law. No such provision was there.
The word may has been issued.
Yes.
May has been issued that before serving notice under section 51A, the person by whom the tax is be payable may deposit the tax as per his own assessment.
Thereafter, my lord, further own assessment is
or ascertained by the authority.
Yes, in my case, ascertained by the authority only. I am saying
Yes.
that I am right from the beginning. I am saying I am not liable to pay tax. Why he will issue me a notice? He will want to issue a notice. He has to issue a formal notice. And formal note, like in the case of
Okay, it is the word first of all the may has been used.
Yes.
And there is no default clause.
the repercussion is there, my lord.
So there is no default clause after subsection 5. So it is not mandatory in
No, it is, my lord.
nature.
Once the notice, kindly see notice, my lord, page 118. If they have not issued, then that's why. If it is not mandatory, it has to go then. Why it is there? If the assessee want to pay any tax anywhere, he always can pay, whether this section is there or not. He is always paying. So why this section is made, my lord, kindly see page 118. My lord, page 118, this notice was issued to me.
So you have challenged virus of this
Yes.
provision.
Only to the extent that why the officer will ask me to pay the tax. Because, my lord, kindly appreciate why I am showing, sir.
According to you, it is offending which provision of the constitution or which provision of the parent?
It is unconstitutional because the settled law. If any person has to be punished because of the set principle of law, he cannot be asked to pay the tax like this. If he ultimately has issued me a notice so that I can contest, here he is asking me to file even a reply. What reply? That means he want to know my arguments in advance. This cannot be permitted, my lord. There is a settled law. If anybody has committed any kind of offense, crime, non-payment of tax, he has to be served with a notice. Entire burden is on the department. I read a division bench decision, which fortunately I argued and I succeed before this court. We say the so-called notice only can be issued after investigation, fact is ascertained, and an opportunity is given. Entire burden is on the revenue. My lord, kindly compare with the criminal law. Unless a charge sheet is filed, can there be a trial? There cannot be a trial. Therefore, unless a so-called notice is given, and so-called notice has a certain duties cast upon the department, they have to give the reason why so-called notice is issued, why this allegation substantiate this allegation with a certain documentary evidence. Therefore, why this provision is made? There are some ulterior purpose so that the officer get to know everything. He will not pass any order. Law clearly saying he has to pay with interest and penalty. Therefore, why this exercise? If suppose, my lord, this section goes, subsection 5 goes, what is the loss to the revenue? Taxpayer is rather beneficial because he will wait for the notice. His consistent stand right from the very beginning is there. I am not liable to pay tax.
What is 70?
Therefore, this subsection is issued. And my lord, there are many components of it. I will just read it. 73. My lord, 73.5 also, my lord, read. Kindly read 73.5. I have challenged both. 73.5. Page 81, my lord.
1 minute, I am coming. Yes.
But one moment I would like to interject in this point, though I do not like to interject. A constitutional challenge of a provision of an act must be based on violation of the constitutional provisions. Nowhere in the application or nowhere in the notes of argument, it has been argued by the petitioners that 73(5) and 74(5) violates any article of the Constitution. So to challenge a provision constitutionality, the threshold must be covered that this violates anything from Article 13 to Article 21, 22, 23. So that has not been challenged. Just merely saying a provision being unconstitutional from the side of the bar would not render a provision unconstitutional. It has to touch the touchstone of being violative of Article 14, 19, 21 or whatever provision. And the provision says, this provision after reading, conjoint reading of the Act, it says the assessee may pay. So it does not give the entire liability of shall, and the rule shall has been amended and made into may. 142. Therefore, my lord, this constitutional challenge has no legs to stand because it has not been challenged on the light and teeth of any violation of the constitutional provision as emancipated under the Constitution. If he has to answer, my lord, I have just pointed out, so he can answer it.
Just point out, my learned friend has not filed any reply since 2019 to till date about the challenge to the vary of the law or the notification or anything. Does the state file a reply of 2-3 pages? So there is no, in fact, the opposition from the other side, which should have. Now, my lord, kindly see. That's why I'm saying, if you can do it, I also can do it. My lord, page 83, subsection 5. Sorry, page 81.
Yes.
81, subsection 5 of section 73.
Same, may.
Same.
May.
I will
Same
point out the
provision.
difference, my lord. Why? It says the person chargeable with a tax may, before service of a notice under subsection 1, as the case may be statement under subsection 3, pay the amount of tax along with interest payable thereupon under section 15 on the basis of own ascertainment or at tax as ascertained by the proper officer in the form of writing of such payment. Therefore, it also says, if it is violate, my lord, now answering to my learned friend questions, it violate the provision of the act itself. That is the ultra virus, because the law has laid down. My lord, kindly come to the section 75. Kindly come to the section 75. Provision has been made how the process of law will go if a notice is issued under subsection 1 and 73.
Section
75.
Yes.
I will just point out why it violates the vary of the act itself, and then the constitutional article 14. It is so arbitrary. It has no basis. It beyond the reasonableness, anything. Now, this is the provision. It says if any notice is issued under section 73 and 74, then a hearing has to be given. But 73(5), no hearing is. No adjudication. 74:10 also, my lord, read. 74:10 and 73:10. Time limit is also there for passing an order. No time limit under section 73(5). My lord, kindly appreciate. It is not the may is always a may. Then why it is required that? If the government has not want to force it as, then it cannot be academic. If the parliament made a law, every word has some meaning. If the subsection was inserted, for what purpose? Which my learned friend, when his turn, will explain. Kindly come to the subsection 10 of 74. Time limit is there, Milo. For the application. There are so many differences I will point out. 83, Milo. Page 83. Subsection 10, Milo. The proper officer
The proper officer shall issue the order under subsection 9 within a period of so and so from the due date of furnishing the annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relate to or within 5 years from the date of erroneous refund. There is a time limit for passing an order and it has to be read along with the subsection 2, my lord. Subsection 2, time limit for issuance of notice, my lord. Subsection 2, the proper officers shall issue the notice under subsection 1 at least 6 months prior to the time limit specified under subsection 10 of the issuance of order. This time limit is not there under subsection 5. Therefore, that's why, my lord, my humble submission is that the law, as it is not the first time the tax has been imposed. Tax has been imposed since independence, even prior to the independence. The law is already there. We can refer Central Excise Law. We can refer the Finance Act. If a so-cause notice is issued, so-cause notice has to be decided. There is a time limit for issuance of so-cause notice. There is a time limit of decision of the so-cause notice. There is a representation has to be considered. It is written, my lord, subsection 9, my lord, kindly see, subsection 9, 83. The proper officers shall, after considering the representation, if any, made by the person chargeable with tax, determine the amount of tax, interest and penalty due from the person and issue an order. That is for the subsection 1 only. For subsection 5, if a person, like in my case, they are asking more than 50 crore rupees, just pay with interest and penalties. This, under subsection 5, a notice is issued. Such a huge, no documents, no basis. Why I should respond? Because the law also says you have to reply to that. If reply I have to given and no adjudication, my lord, what is the purpose? It is total arbitrary. Kindly see, my lord, there is a form under which this notice is issued. The part B, this I have to file a reply. For what purpose? If my adjudication will not be done. With the greatest respect, my lord, I know it. I have been visiting the North Block for 15 years. There is some mischievous mind probably has worked behind such provisions. I can never foresee in any law, my lord. In this country, Chief Justice just retired said we have given a justice to a Kasab up to Supreme Court. But here, no adjudication, nothing. First, you will issue a notice asking me to file a reply. What kind of this provision, my lord? What purpose it will serve? Except to harm an assessee only. And to benefit, to improve there is a settled law. I can show any number of judgment. If a notice is issued, it can never be improved upon. Notice has to be decided exactly. I just read, my lord, the division bench decision. If I can read just one line again, my lord, the division bench, which I argued that what stated in this Magma Saranchi decision, era 26, page 22. It clearly states the adjudication authority is to adjudicate on the demand in the so-called notice based upon the allegation made therein. If prior to the so-called notice, that's why the word says prior to the so-called notice. I never heard. There has to be some basis. They have to show me what is the objective reason for bringing such kind of legislation. But there are so many provisions they inserted later on, even taken back also. Once we pointed out. Why reply they are asking?
Now, who will serve notice under section 51?
50 is the interest, my lord. Section 50 is the interest. Referring to section 50 or 51, man?
Pay the amount
along with interest under section 50. 50 is the interest.
A person chargeable may before service notice under section 1.
Because if I have to pay the tax, I have to pay interest also. And it is also law settled. Even for asking interest, if I am disputing, they have to issue me a notice. My lord, let me show the form. GSTR, which they are issuing to me. DRC 01A. They are asking us to file a reply. Mother, you cannot. Any proceeding, my lord, has to lead to the ultimate conclusion. If it is not leading to any conclusion, these provisions are totally arbitrary. It violates Article 14. I'm just looking at that form, GSTR 01A. Yes, 517.
517 of
book, my lord.
Yes.
This is the GSTR 01A, intimation of tax ascertained as being payable under section so and so. They are cutting short the entire procedure laid down in the law. Any criminal law, civil law, taxation law, there are certain set of procedures are there that cannot be cut short. 517, my.
No, the court just want to ascertain what all the legislature has done, keeping a window open, that before serving notice under subsection one of section
once his turn will come.
one, you may deposit the amount as per your own assessment or as per the assessment made by the authorized officer.
Yes, word is very important.
What provision from the constitution has been violated?
Yes.
Or which statute has been violated?
Yes, my lord. The my lord has said assessment. What is the assessment? How it
Actually, a window has been kept open, that using the word may and no default clause is there.
Yes.
That means legislature did not intend that let the subsection be act as a mandatory provision. Will operate as a mandatory provision.
I am coming. I'm
It is
sorry,
not the intention. It was not the
report, my lord, kindly refer to the section 83. There are so many things I can point out.
Yes, 83.
There is a serious repercussion, my lord. There is serious repercussion.
Yes.
Section 83, my lord.
In case of electricity, the authority raised a bill on the basis of provisional assessment and final assessment.
Yes.
And anyone can deposit the provisional assessment. So asking the person concerned that if you can deposit, because tax is to be charged, paid by him, the person by whom the tax is payable may pay according to his own assessment or according to the assessment of the authority.
There's a serious repercussion I am pointing out, my lord. Kindly refer to the section 83.
The process goes like this in taxation law. ASMT form is issued, assessment is done. After that, DRC 01A, I'm sorry to my learned friend for interjecting, DRC 01 is issued. So before DRC 01A cannot be read in isolation. I will answer your lordship after my learned friend completes, but there's a process.
Yes, yes.
My lord has asked me the question, what is the repercussion? I'm just pointing out. There is so many repercussions. My lord, kindly refer to the section 83, my lord. Section
83, yes.
Page 90. 83. Page 90.
Yes.
Where after initiation of any proceeding under chapter 12, chapter 14, chapter 15, the commissioner is of the opinion that for the purpose of protecting the interest of the government revenue, it is necessary to do so. He may, by order in writing, attach provisionally my property. Therefore, my lord, now refer this section fall under this chapter only. If proceeding is initiated, if my lord, some FIR is there, I can come before my lord to quash it. But in imagination, something is there, I can't come for a relief even. Therefore, my lord, kindly refer to page 81, chapter 15. My lord, kindly refer to page 81. It says the chapter 15. Chapter 15 section 73 and 74 fall under section chapter 15 only. Now, Milo, kindly refer the rule 86A. There are so many provisions. They are hurting. In fact, section 22, 23, cancelling registration, blocking my bank account, blocking input tax credit, every action they take it, every possible. My lord, kindly imagine a situation, my lord. Today, a policeman come before my lord, so and so has committed a crime and rape like this. My lord will be baffled. But unless a charge sheet is given, I have no opportunity. If investigation is done, FIR is registered, there is a set of procedure. Similarly, here, it is going to affect. Today, my balance sheet, my banker will not give me a loan. My auditor will reflect in my balance sheet. There is a contingent liability, 55 crore rupees. No notice has come. Time limit. Why the time limit put by the legislator for issuing a notice under subsection 1?
Okay, got it.
It is authorized, my lord. It has no consequences if it is goes. But if it remain, it affects the interest of the taxpayers only. Why it was not there from 1944 Excise Act made till 2017? This subsection is made with, God knows, no benefit to the taxpayer, no fairness. My lord, read my written submission, just one paragraph about it. Page 4, 5.1. The impugned provision do not provide procedure established by law. Issuance of so-called notice along with evidence and allegations, followed by opportunity to respond to said notice, further followed by the process of adjudication after giving opportunity of being heard, passing an adjudication order. It is submitted that in the absence of such legal procedure embedded in law, seeking a tax along with interest and penalty as communicated by the officers are unconstitutional because total arbitrary. Because it has a repercussion. 83 section, my lord, read rule 86, where the ITC can be blocked. Kindly refer, my lord, section 22, my lord. Only because of that, my lord, the once this, everything is triggered, my lord, once this notice is issued. What is refer to the section 29, my lord. Section 29, subsection 2, my lord, page 43. Cancellation or suspension of registration, GST registration. In fact, my lord, my understanding that more than 1,000 cases so far has been decided by various high court. Officers just issue such kind of notice, cancel registration. Cancellation registration means you cannot carry on business at all. Whatever and wherever situation is there, you can't make any supply at all, which is first time I have heard. Such kind of rigorous provisions they have made it. In under income tax, even a person stated to have stashed the entire black money in the Swiss bank, his PAN number never cancelled. Never. A person who has committed a crime of murder, his passport is never cancelled. But here, such kind of notice, it is a serious repercussion. A license will be cancelled, GST registration. The proper officer may cancel the registration of a person from whom such date, including any retrospective date, as he may deem fit, where a registered person has contravened such provision of the Act or the rule made thereunder. A person paying tax under so and so, a registered person other than specified so and so, his registration is cancelled. Non-payment of tax. Why I will file a return for these taxes when the tax itself is not payable? Therefore, my lord, to say that there is no repercussion, that is not correct. Let me point out a direct decision, my lord.
Yes, yes, yes. Go on.
Without issuing a proper so-cause notice, they were demanding tax. That those so-cause notice also struck down.
Yes.
Kindly see serial number 4. Just I will take one line from the index itself. The so-cause notice, essence of that, there has to be allegation and evidences. What they are issuing such kind of form, like here is a DRC 01A, they are issuing DRC 01. And just
yes, yes, that issue would be addressed as to whether the so-called notice was proper or not. Yes, you have stated that there must be certain material to show that fraud, misrepresentation, or anything like that allegedly committed by the.
Yes, yes. Now, my lord, kindly see serial number 6 of my another judgment from the Madras High Court, para 14. From the index itself, my lord, I have quoted the paragraph without consuming much time. Index serial number 6, para 14 of this decision I have quoted here.
Page.
Page B, my lord. Index page B of my compilation.
Oh, yes.
B at the bottom, serial number 6.
Yes, yes.
It says, it is para 14 I have quoted here. It is also a settled law that the so-called notice issued without any tangible evidence and based only on inference involving unwarranted assumption is vitiated by error of law. 73.5 and 74.5, they are doing exactly this. 74.1 and 73.1, they have to give me the so-called notice with evidences. Here there is nothing. And sometime my lord has ruled, may it depend upon the entire code of the scheme has to be read. If it is may can be read as a cell can be read as a may. It has a repercussion, my lord, if that notice is issued, need merely not a piece of paper. They can take various action, different law. Even arrest also could be made. My lord, if read the section 69, they have the power of arrest. Therefore, it has a repercussion, my lord.
Okay.
My lord, if permit me just one or two judgment, I want to show it on an issue which I referred the entry 53 has not been deleted for electricity under schedule 2. Similarly, certain other entry has also been not removed despite introduction of GST. Therefore, I have given the some judgment serial number 13, my lord. Serial number 13 for my compilation C.
Yes.
At the bottom, it is the 10 Network Limited versus State of Bihar. This is after introduction of GST, this judgment came. It says we cannot but hold that the tax on entertainment and amusement were never intended to be subsumed or consumed within the definition of the service as defined under the GST law. What essence of this judgment is the Patna High Court has held that the GST is the subsume of the various taxes. And the High Court said the taxes which has not been subsumed in the GST still kept outside the GST. That means no GST will be levied on that. I am drawing analogy from the same. The entry 52 under the state list remain same as before GST. And for bringing GST, entire constitution is amended. 101st amendment. The so many entries were subsumed and amended and new provisions were made. But entry 52 remains same. Therefore, my understanding and as per the judgment of this, that no tax could have been levied unless under the GST, because that entry has not been subsumed, it remain outside. And one more repercussion of that, the GST is being levied by the central and state both on the similar proportion. Entry 52 give the power only to the state. And that is a different statute. They are collecting like electricity bill, electricity duty in anyhow, every person is paying in this country under entry 53. So therefore, no GST could have been levied. So I have the couple of other judgments is there which says if the no tax is intended to be levied by the parliament, in the guise of that no tax could be levied. I have quoted the two judgment of the Supreme Court, serial number 9 and 10. The serial number 9 says if the tape record is there, the cassette is there. Even though tape record cannot be run without a cassette, that does not mean like the computer cannot run without a software. If software is exempted, you can't tax a software as a computer. Therefore, a petrol or diesel, without using that, a vehicle cannot run. Therefore, because the vehicle is being taxed, that does not mean necessarily you have to tax it. This is my arguments, my lord.
Yes. So if your argument is summarized that the electricity cannot be stated to be a service, it is good. So it is not taxable. But and corporate guarantee is a actionable claim. It cannot be taxable. Subsection 5 of section 3 and section of section 74 and 73 are ultra virus
and arbitrary both.
And arbitrary in nature.
And the notice, well, electricity once treated as a
And
goods and
it
nil rate
cannot
of
be
duty.
stated to be composite.
Yes.
Supply also. And it is the main your argument.
Yes, and the
First
notification
argument,
also I have
just one
challenged.
more. The first argument is notices without reasons. That is the first argument. If the notice was
Notice
everything
is
goes.
without reason, there is
Notice
no
74
case of
ingredients.
misrepresentation, fraud, etc. Yes. That's all?
That's all, man. Grateful.
So you concluded yours. When you will reply, you will give reply.
My learned friends, another matter has been placed on 15th June. So any day after
15th June?
No, May.
15th May. 15th May. Kalki. No, 15th June. Lordship, after vacation, because we'll need time. This matter will be requiring time.
Already on the board.
Lordship, the vacation
Already
is
on the board.
Lordship, first of all,
Lordship,
first of all, my learned friend, with due respect, I'm saying he's adopting guerrilla tactics. On the last occasion when we were not present, no notice was served. Right now, today in the afternoon, we received a notice that the matter has been placed, Your Lordship. We are completely caught unaware. So my learned friend has to serve us a notice that the matter will be taken up. We are completely unaware, and luckily we have got the brief in the car. Otherwise, it would have been very difficult for us. And he has made submission for, correct me if I am wrong, for 2-3 days.
Actually, after vacation, I have circuit bench. I am to go. I have circuit bench.
When my lord comes back from
Comes back, Your Lordship. Because this requires extensive hearing, Your Lordship. He has raised point regarding constitutionality also.
23rd and onwards, I shall be able to.
Whenever you
24-25 ওইসব ভর্তি করেছি।
I am on vacation because Delhi High Court is on vacation. Supreme Court.
July then, Your Lordship, because Delhi High Court.
When you will be because before vacation we have only 3 days and 5 days.
Yes.
You forget about the last day.
We will not be doing justice. My learned friend has.
Then, my lord, keep it as parted and in the July, my lord, sometime.
Much. July any day. July any day, Your Lordship.
July.
council out of 10 and tried to, my lord, to verify the eligibility of the students. For that, the existing affiliated colleges were intimated to give us the information as to the eligibility of your students. So nothing related to the new admission, new registration is not at all to that effect. So and report, it is nothing new, no document, new document I'm relying on. A report just answered to the
Right, it is a
application as well as their supplementary affidavit. I'm just clearing the doubts by way of this report. May I just file it?
But,
today?
File response to that report.
No, my lord, very short matter, my lord. Very short.
You file response to that report and come.
My lord, tomorrow to 12 noon, tomorrow, my lord. Kindly take support.
I have
May I
no
place?
doubt.
Why for?
Otherwise, my lord,
He is saying there is no, you
No,
only.
may I place my case, my lord? May I place? But we have the document, my lord. We are seeking, my lord, affiliation. If I get the affiliation, my lord, then my recognition.
You stated 8 May was the
Last date for recognition as well as.
Tomorrow is 14 May.
But let them show just for once. Let them
But-
produce the.
Okay, what
Just one page,
are
it will
notice?
clear.
What
one.
are notice that?
I know that the long, that lengthy.
Heaven would have been told.
Yes. What is the urgency, my lord? Can you please?
Okay.
My lord,
It is of 29th April.
29th April.
Then would have been told on that date. Okay.
My lord.
Yes.
My submission of eligibility documents of all admitted pharmacy students, including management quota, my lord. We have already took admission, my lord. We have admitted the students under management quota, my lord. They will suffer, my lord.
Submission of eligibility document of all admitted
Yes, my lord.
pharmacy student, including management quota.
Yes, my lord.
That those who have already
Already,
admitted.
we have already, my lord, admitted the
So
student.
what are you
Under
saying
the
that?
application, that is a gross offense.
My lord,
that
under
without
management quota, my
affiliation,
lord.
They have admitted students.
My lord, under management quota, my lord, we have admitted students, my lord. They will suffer, my lord.
Well, how can they? They have no affiliation to run the college. Now they are saying that they have.
My lord, they have
Can you
indicated
report
certain.
that?
So some student took admission in your college, though you have no affiliation.
My lord, we have applied.
Admittedly.
No, my lord, we have applied for affiliation, my lord, and we have also requested for fresh inspection, my lord.
The story is completely different.
However,
And my lord, we have beat up
however,
with the
certain
deficiencies.
okay. However, by this
And I'm late by
notice
Mr. Chatterjee.
dated, yes, by this notice dated 29th April,
Yes.
Chief Administrative Officer of such and such. Yes,
Addressing
yes.
whom has been addressed.
Can you see the reason?
Asked to submit the eligibility document
Now,
positively by 8 May. So what is the urgency?
what is the reason? The reason they are saying is, that I don't have a completion certificate. They are saying that I can't give you affiliation. Why? Because I don't have the completion certificate. The completion certificate is all with me. Kindly have a look.
So why you are updating that? Since they have instructed you to submit certain eligibility document of all admitted pharmacy students, you will suffer serious loss.
Can you look to 33? 33. আচ্ছা, উঠে গেছে? Lord, kindly have a look at 32 once. দেখতে পাই না।
Yes.
Inspection.
13 December was done.
Then turns over. The council arranged inspection of your institute on such and such to assess the available infrastructural and other facilities to conduct the 2-year diploma in pharmacy course running at your institution in the academic session 2024-25. However, it has been observed from the inspection report of your institute.
You are reading from? You are reading?
33.
33 minutes.
33, yes. Yes. Yes.
Yeah, I'll read for you, Lordship. The council arranged inspection, which your Lordship saw, my lord, on such and such to assess the available infrastructural and other facilities to conduct the 2-year diploma in pharmacy course running at your institution in the academic session 24-25. Running at your institution, kindly marks that. My learned friend was very vociferous that how did they admit? They know very well, my lord, from the management quota, there are students who are studying there. There is no dispute on that at all. Then,
However, it has been observed from the inspection report of your institute that there are following major deficiencies in the infrastructural and other facilities required to conduct the course. Now, building infrastructure, building under construction. The building is not under construction. My lord, I want an M Pharma. That is why I am making a third floor, which is also, my lord, made through, my lord, a sanction plan. There is building is not under construction. Then in any case, my lord, I cannot then, if I have to, my lord, do anything with respect to repairing or anything, my lord, I will have to, my lord, stop the college from running totally. That is not the law. Second, academic infrastructure, aseptic room not yet completed. It's all there. Academic infrastructure, fume chamber not available. All this is given, and then, my lord, herbal garden not available. I will show your lordship, my lord, everything is available. Everything is available. Can it turns over? This is our answer to that. That is why, my lord, if they go and inspect right
model
now,
pharmacy, incomplete model pharmacy,
if they go and
pharmacy,
inspect right
lab
now,
not, social pharmacy lab not available.
everything is there. Let them go and inspect today, they will find everything in place. Everything in place.
Now, may I just answer to the question? The process is that first, consent to affiliation is granted. They apply before the PCI and the West Bengal Vocational Council. Based on preliminary 5 documents, that's land related deed, that you have applied for sanction plan on that, on assumption that the institute has got a sanction plan and it is ready with the infrastructure. The rule is that before you start or apply, you should be ready with your infrastructure like building and all these things, and including the paraphernalia. Now, my lord, kindly just, I'm just a back for a school. My lord has already, my lord, dealt with this kind of matters. That's a school. When the school applies, a DLIT team is, my lord, formed. They go, they find that according to the RT Act, the school is informed. Then it is proceeded to grant a no objection. Here, a college or institute should be ready with the infrastructure, then should apply for the affiliation. So based on the preliminary 5 documents, financial, this land document, sanction plan, trust deed, we give them that consent to affiliation means, yes, you can now start to open the college. That is subject to fulfillment of all other infrastructure as well as the approval from the Pharmacy Council of India, which grants the, yes, you can run the course. But that is subject to final approval, final affiliation by the vocational councils of the state. We then goes for inspection. If we find is all is in form, so we give them the final affiliation. Here, this page 33, we found that these are all the major defects. Major defects. So we have straightway, my lord, refused to give them the affiliation. And all this affiliation, all this inspection are in a time-bound manner. This is not a new matter. Various other matters also, the coordinate bench, my lord, benches have already decided that out of the turn, no colleges can be given any preferences out of the turn. Now it is in the May. In January, last affiliation chance, student admission already over January. December, January, all over. Now in the month of May or April, we cannot open because we're in the verge of, this internal assessment has to be conducted now. All the affiliated. No, my lord, they have kindly, if your lordship kindly peruse this report, the photographs, this is the condition of their building. They say that it is complete. It is all their document, nothing new and nothing. They are incomplete with fire safety. They have not yet received the fire safety. Now their affidavit, my lord, kindly peruse my report once. Then I will one by one, my lord. may I straightway go to my lord page 3 of my report?
I wish I.
May I read out, my lord? If your lordship's on my report. Page 3 of my report, we have stated that prior to apply, our institute
I
must,
even could not understand
my lord,
that in the month of December, the institution was inspected by the competent authority
yes, my lord.
and found that there is some deficiency in service or infrastructure. Now, in the month of April, they have issued a letter asking the school authority or management to submit the document of the admitted pharmacy student.
Yes.
So what urgency you have got that immediate intervention of the
not
court
meant
is
for
required.
this non-affiliated
If
college.
immediate intervention of the court is not required, you will suffer irreparable loss.
Saying is that they give affiliation only in May. So if I skip May, my lord, then I will again have to wait for another 6 months. And the students who are studying, who are already there, my lord, from the management quota, and please kindly appreciate, my lord, that these are students of B farm. These are not M farm. They inspected, my lord, the entire building. The M farm is still being constructed. I have not paid for affiliation there. There is no student there in M farm. This is B farm.
Now it is affiliation 1 year,
2 years.
2 years.
2 years. And kindly see, my lord, it's there at page 33. So if they don't give me affiliation now, these students will suffer. Forget about me. I will only include, my lord, a bad name, nothing else. But the students will suffer. And kindly see, the Pharmacy Council of India has given me, my lord, the affiliation. Have a look at, my lord, page 31.
We say that admission of the students is itself illegal, not irregular, absolutely illegal, without authority.
Ekdom illegal. And if it's illegal, my lord, they need to take steps with respect to that. They haven't. Have a look at 31. Page 31.
No, you are now taking this plea.
No, not now. This is here in
Page 33.
31.
Running at your institution.
Exactly.
Such and such.
Exactly. How is it running? Page 31.
You have not stated that you are illegally operating and
No. That is only this interpretation will not do, my lord. He says the council arranged inspection of your institute on 13th December to assess the available infrastructural and other facilities to conduct.
Why is he so? Why does he not want
to
give me
conduct the 2-year
Have I done
diploma
anything
pharmacy
wrong? Let me
course?
ask this question to myself. Does he have anything against me? No. He's a state authority. He should be, my lord, very fair. If I have complied with whatever is required under the law, he should not have a personal enmity against me.
It cannot be run, my lord. This first time they are seeking affiliation.
I am running.
No.
Said I am running.
To conduct the 2-year.
You have not cancelled those students.
If they are running, so they have to produce that earlier also they have obtained this any permission from any authority.
31. That's
It
what I'm
says to
showing.
conduct. It should be, there might be a grammatical mistake of this letter, to conduct the 2-year diploma course and to run at your institution. It should be like this. How it can be only interpretation and misinterpretation can improve
when
their course.
academic session
Yes
24-25 starts.
Yes, then
However, which day you are when this academic session start or commence? When?
It academic session commences, yes.
24-25.
24-25 January. Yes, the academic calendars are also there.
33 is also. My lord, kindly first is 31, my lord.
Yes, page 42.
He is trying to modify this letter. In place of running, you want to us to read to run.
Cannot be.
That is the future incident.
Yes,
No. Future incident. When?
Page 42. This is the academic calendar.
24-25.
Yes, 24-25.
Court is not so expert. You say when 24 academic year, 24-25.
the completion started, my lord. The academic calendar 42.
42.
Yes.
5th of December 24.
Yes. Eligible.
What is academic calendar?
Have a look at
42,
42.
42 of repetition.
Sir?
Yes.
Your
42
lordship, fine.
part-time diploma in engineering, such and such.
Yes.
Admission, completion,
And diploma in pharmacy. So, admission is tentative
23rd November
23rd
2024.
November.
Yes.
Online registration for pharmacies
30th December 24.
Commencement of first class of pharmacy
Yes.
in the month of
August.
second year in the August 2025.
So 24.
So why May? Why are you saying May?
No. Commencement of
He said that they will
classes
give
of
a lot
pharmacy.
affiliation
Classes of pharmacy.
May.
No. Classes of pharmacy is 5th of December 24. So already commenced.
বলছি তো সেটা I'm saying
Now already commenced. Commencement.
So you have recognized that.
Absolutely.
You have acknowledged that they are running.
And she's 31.
No,
my lord.
that is not at all, my lord, running. We say we have straightway, my lord, rejected, my lord, in view of the above. My lord, page 33. In view of the above, the council regrets to inform you that your appeal for affiliation of the 2-year diploma in pharmacy course for the academic session 2014 has been rejected. So now, therefore, after they, my lord, come before approach the office of the council with representation. Now we have fixed a time for their. We have, my lord, demonstrated the events in my report. Now, after this rejection, page 4, based on these deficiencies, the council by its my report, my lord, found by Mr. Anirban Bose.
Supplementary affidavit, yes, it is report.
Might be this one, yes, this one, my lord. Page 4. Based on the above, these are the defects. Page 3, we have categorically.
That is a
yes, that is the rejection. Yes. Now, my lord, next, based on the above, page 4, Roman 5, based on the above deficiencies, the council by its letter dated 10th January 2025 refused to grant affiliation in favor of the said institute. Thereafter, the college authority by its letter dated 5th of March 25 stated to have approached the Minister of Technical Education, Training, Skill Development and CEO of this council and with some documents. They approached the council to convene a meeting with the senior officials of the council members of the pharmacy expert. Considering the above, a letter dated 7th of March, which is a part of the writ application also, was issued from the council in the name of the principal SBSF College of Pharmacy with a request to appear before the expert committee on 10th March 2025.
Correct.
On the scheduled day, all the senior officers along with expert committee members were present, but the principal of the college remained absent, citing a reason that they had also applied for B Pharma, that the PCI inspection for B Pharma would be held very soon. Consequently, the principal was stated to be busy with that work, and indicating that the same incomplete building would also be shown for B Pharm, despite its being incomplete. They came with a lady, introduced her as a faculty member of the D Pharm, but her name was also not reflected anywhere in the SIF, Standard Information Format of PCI, submitted to the answering respondent. According to the PCI norms, faculty listed in SIF by one student must be retained for at least 1 academic year. Otherwise, they will not be counted as faculty. The inspection report also indicated that one faculty member was absent at the time of inspection and left the college. Now, the photograph of the building itself shows it is an incomplete building, and completion certificate from the competent authority is not available. Now, in the supplementary affidavit, in their supplementary, my lord, kindly comes to their supplementary affidavit, they are coming up with page 7 of their supplementary affidavit. It should be from, in case of municipality, it is a municipal
Page 5.
Panchayat Samiti, page 7. It is from a private person, architect.
Arey na
who
na.
is-
Ah,
কি
I've given the completion certificate from today. কি বলছিস?
কবে
আজকে দিয়েছি, তোকে দিয়েছি তো।
টুডে কোথায়
দিয়েছি
না
দিসনি? কেন দিসনি কেন? না, I'm sorry.
টু
Supplementary affidavit.
Yes, my lord.
further supplementary
Supplementary affidavit.
Page 5.
I am the last person to rely on
But-
this
but-
by a private
yes, yes.
individual.
Yes.
Last person.
Now their first supplementary affidavit.
No, no,
They have
kindly ignores this.
my lord, may I just
Kindly ignores this.
my lord, it cannot be my lord run as a throughout the year. First, my lord, they are coming
The
with page
completion
7
certificate
saying
of the
a
throughout the year.
yes, it is their supplementary. They are stated in their supplementary affidavit that
10th March was also there was a
Yes,
inspection.
but
yes.
they did.
On that day, they could not satisfy
No,
that
but they don't want to be satisfied.
No,
The
now
problem is,
now
I'll tell you a lot.
your building completion, you have 19 March.
Yes, the
19 March.
building completion certificate is
So
given
every
19.
day they will go and inspect.
No, my lord. They are
And
saying,
you buy installment, you will
Nine.
today you will construct
No.
one building.
No.
Tomorrow another construct one
because the
building.
building was all
And
there.
you are so the future of the student. I have already they have taken admission. Consider what will be their future and showing their future. They will go on.
I'll tell you, Lordship, my lord. There
No
are,
illegality. Okay. No urgency.
my lord, kindly.
You will face the consequence. Why?
Well, the
Without
students will
completing
face.
all formalities. Why you have?
But we have. I'll tell you, Lordship.
Why you have
1 minute's time, I'll tell you, Lordship.
to take admission of the
I
student?
just give me 1 minute.
rejoin one after
Allow me
yes
to
yes
say 1
yes
minute. Kindly turns to 31. Kindly looks to 31.
31.
This is below the Pharmacy Council of India's approval. For the year 2024-25, and I can take below 60 students. Lordship got that below? Then, kindly have a look at, I showed your Lordship page 33.
Which is which yeah,
24-25
that means approval status was rejected.
was granted.
Huh?
Approved.
D Pharma.
D Pharma.
Pharma was
Approved.
Yes.
I am on D Pharma.
You are saying B Pharma.
No,
D Pharma.
D
D Pharma.
D Pharma. That is
আচ্ছা, এবার
also
আমি
my
একটু
lord.
বলবো।
Oh, sorry,
Approval
sorry,
status.
এবার আমি
sorry.
একটু বলবো।
When it was
কিচ্ছু
issued.
বলিনি যখন।
না ঠিক আছে
Decision letter of Pharmacy Council of India.
My lord.
Yes.
So now that is approved. I am not on B Pharma. That part is not ready, my lord. I have not even praying for that. But I am on D Pharma. This is Pharmacy Council has given me, my lord, the approvals for 60 students. And in terms of that, I have taken in, my lord, 60 students. And they agree, my lord, that I am running the institute. Now they found out certain lacuna. My lord, what is the lacuna? The lacuna is, my lord, the gravest lacuna is what they say, my lord, is no completion certificate. The
no,
first,
there are other also I have not completed my report
Achha, I will show the report.
yes
Now, what they are saying is the completion certificate, my lord, which I gave by way of a supplementary affidavit initially, was not valid. It is, my lord, I would not have even placed it before your lordship. That was by a private individual, cannot happen. My lord, we have got the completion certificate from the authorities. The building was there, it was being used for the D Pharma, and it's going on, my lord. The certificate is granted on the 19th of March. That is the one which is relevant, my lord, for your lordship's kind consideration.
That is the building completion certificate.
completed.
There are many other.
I am now showing one by one. I'm showing.
Fume chamber.
But I'm showing one by one.
Pharmacy lab.
Give me 1 minute. I'm
moreover
showing.
they do not have the fire safety certificate. They have only applied for that recommendation. With that letter they are, my lord, running with.
But I am saying so. Let them go today, tomorrow, whenever they
Not
want
at all
to,
possible.
whatever they want, because
Kindly.
they will do it in May, my lord. It's under their own
On the
submission.
mid of a
They will
session,
do it.
a mid
No,
of the
fire
session.
certificate is a document. You produce it.
There, you lordship wants to
Show the fire certificate.
no
On the mid of the year, it is not possible.
problem at all. No problem.
This matter is
Now
not
what
a, my lord,
happens-
is already, my lord, it is not
Accept,
basic.
accept,
It is a, yes.
Accept.
My lord, চাইছেন দেখেন. My lord, even the division bench also did not interfere in the last year. Out of the turn, at the mid of the
There is
session,
no out of
no new
turn.
affiliation can be granted.
I am not saying it's out of turn.
Absolutely, in the month of May, we cannot inspect. We are on the examination round now. which was over in January. My lord, kindly, I will not.
না বলতে পারি আমি কি করে বলে আমাকে বলতে দিচ্ছে না না বলতে পারলে আমি কি করে মহা মুশকিলে পড়েছি আমি
Very sorry, very sorry.
আরে বলতে দে
আচ্ছা,
একটু আমি
আচ্ছা,
আধ
Place after my learned senior friend.
Explicit that the learned single judge did not exercise any discretion in favor of observing that the student would not be in a position to acquire the
আমার মাইকটাও কাজ করছে না যে আমার আওয়াজ
আচ্ছা, sorry.
তোর মাইকটা কাজ করছে তুই চিৎকার করছিস বুঝতে পারছি না তুই নে
One thing Mr. They, what they will take advantage of that. Rightly or wrongly, they have taken admission of certain students. They are now pursuing the course.
No, that
Now,
is also
what would be their future?
That is, my lord,
They will suffer one year.
No, that is also, my lord, illegal. In the same point also, the coordination has taken decision. They cannot do like this. I shall come up with those judgments. Already, not a single one. In many series of matters, Honorable Court has decided, no, this way, you cannot be given further chance. They have taken.
Very well.
60 is the capacity. They say, we have already got 45, 15 more students we have got. So they are saying that is for them, we have already got them admitted in January. So the Honorable Court did not interfere with that. Did not want to. This is absolutely illegal. They are without affiliation. Next year, we will be considering the situation according to even this matter also. Even in a public interest litigation, there is a decision of the Honorable Chief Justice also that many more colleges are doing, my lord, going without proper infrastructure, lack of infrastructure for the second round to cause verification in respect of those delinquent colleges. After that, yes, even the running colleges also got their affiliation cancelled for this reason. This plea cannot be taken at this moment. We have asked them to come up with that. Now in the month of May, they are coming up with this.
I have heard that.
Completion certificate.
Kindly, my lord, he is over.
And
have
there
a
is
look at this.
And this, even the PCI rule also. PCI rule also, norm says 180 days class.
Now allow me. Can you turn to my lord, page 2 of that judgment? This is the submission of the council. Today, my learned friend is saying something else. Can you see page 2? Right at the end, Mr. Mukherjee, learned advocate representing the council, submits that if the college is found suitable for affiliation, the last date of admission shall be automatically be extended. It's their submission. Today he's submitting something else. And Mr. Deb obviously appeared there. See, he can't.
It is pre-admission.
My lord, this is of January.
I am saying so.
Pre-admission, not post-admission.
I am in a better footing. He is saying, my lord, that the date of admission. Please, come on, kindly. Now, what happens?
The last date of admission should be extended.
Now,
That's
your admission is
pre-admission incident.
Absolutely.
Post-admission.
I am even
You have already taken admission.
In a better footing. Why I could take admission, my lord, is because of page 31. The center has given me approval, my lord, for running this D Pharma. They are now bringing, my lord, certain things into the picture which are no longer there.
Any other judgment is there?
Well, there are series of judgments that students plead the sympathy that is not applicable, and here the matter is completely the time-bound manner. It was of January 24. At that time, my learned senior friend has relied on this judgment. This was of January matter. It is of January when was the second inspection. Till the time was there for certain days. Now in the month of May, this relaxation cannot be granted.
No relaxation.
What is January and May? First internal assessment has been started. 180 as per the PCI norms. The PCI will apply the lordship. That the class has to be attended for 180 days. Then the final for the final examination, the students will be made eligible.
Whether they have annexed that rule that 180 days.
That is the rule. That is the PCI may apply. PCI guidelines are there. And PCI is the approval.
এবার আমার মাইকটা অনেক হলো এবার মিলার কাইন্ডলি নাও seriously if you
so you bring the judgment I am fixed in one date. It required to be heard. আচ্ছা
কবে? পরশু।
তারিখে
It will only delay the matter. It will only delay the matter. Kindly takes it up on this basis. If on this basis, but I'm accepting the report. I am saying
So
even
your file in form of a report in form of affidavit will you able to file? Otherwise, I am to take this document on record as per oral submission. Yes. Okay, so bring those documents. Bring those documents will be answered. Acha, leaves the matter for further consideration on 19 May.
19.
On 19 May. ঠিক আছে?
2 PM না 10:30
আচ্ছা।
10:30 10:30 10:30 or 2 PM
যে সেমিটি শুরুতেই
যখন বলবে 2 PM না
2 PM গাদা আছে ঠিক আছে। আচ্ছা।
But 10:30
Fairly at the top হবে।
হ্যাঁ fairly at the
Fairly at the top হবে। 12:30
সকাল বলার জোরও থাকবে আর ওর সঙ্গে কথা দেবে।
Oh, 12:30 come on 12:30.
I need energy to fight yesterday.
With him.
12:30? Yes.
12:30
Yes. 12:30.
Thank you.